the 15th of March, 2023. The time is 10:08. Let me take this opportunity to welcome the honorable members here at M46 and on the virtual platform, to welcome the public protector, Advocate Mkhwebane here at M46, as well as her legal team led by Advocate Mpofu, also here. The evidence leaders, Advocates Bawa and Mayosi, to also acknowledge members of the media with us, as well as our entire support staff in their various duties. Last but not least, the members of the public who consistently are with us in their various platforms, YouTube and Channel 408. I want to welcome you today to this session as our inquiry continues. And we now continue to get to the next level of the inquiry. We have the next witness who's been listening since last year to everybody who came to this inquiry. She would have spent most of her time here at M46. We have over 20 witnesses that would have done that. Today it is going to be, from today, it's going to be her opportunity to address South Africans, to address this committee in her own testimony. And so I'm going to be asking that we allow that space. Members, as you know, would have an opportunity later on to ask questions. It's going to be important that we spend in the next few days. I don't know if it's going to be easy or hard, but that's part of the terrain that I'm going to urge that we all observe and interact with the testimony that is in front of us. We did receive a statement yesterday, very long statement, affidavit, I must say. And so I think many of us are still reading it. It will also be important that we walk with the presentation of that. It might be very helpful. And so Advocate Mkhwebane would have taken an oath. She's still under oath. We're not going to do that exercise of taking an oath. She's been with us, as I've indicated, without missing a single day. Even when there were possibilities of her missing, she did not. I'm saying that from the chair. So, colleagues, I therefore would want to take this opportunity and ask and hand over to Advocate Mkhwebane and her legal team, who are going to have to, I think, firstly, give us the landscape of how you're going to go about this testimony, so that we all are in the same page and we follow that. And in the process, interact with the Advocate Mkhwebane. So with that, colleagues, I'm not going to waste any further time. I'm going to hand over to the PP and the team to say, this is the moment you have been calling for. and you would have indicated that you can't wait. In fact, I listened to you on Monday saying Wednesday is too far. And I was saying, but we've already programmed it. We can't have it on Tuesday. But we're here now. We're in your hands. Thank you.
Thank you very much, Chairperson. And good morning, Chair, honorable members, members of the public, our colleagues, evidence leaders. Chair, if you allow me an indulgence to make a special welcome to members of the family. We have Advocate Mkhwebane's two sisters here who are with us for the first time, and Ms. Janetta Mahlangu. We also have the other sister, Professor Maputle. And we have a third member of the family who has been with us from the beginning, supporting the PP. Probably never missed a day like her, unlike some of us. I got that message. And that is the public protector's husband, Mr. David Skwasana. So we acknowledge, we know that they all come from very far, and it was important for them to come and support the public protector. Chairperson, without wasting more time, I will indeed, before asking the public protector to take the stand, do what you've called landscaping, and just briefly for the committee. Chair, you will have noticed from our long statement, which to your disappointment, as you know, it's only the first installment of the statement. But on a lighter note, Chair, we want to assure you that even though we've indicated that there'll be 2 more installments, they'll be much shorter. Because of course, the first statement you'd have seen almost like the first 100 pages is background, overview, and so on. So obviously we're not going to do the background every time we come. We'll do it once, and then the other statements will be much shorter and themed around some of the issues. So on that score, Chair, for the purposes of members of the public who may not have seen that statement, and members of the committee who only saw it yesterday. In a nutshell, the approach, as you said from day one, Chair, this is an unprecedented process. So I'm sure other generations will learn from what we're doing. So you and ourselves have to be inventing methods to make this work. And so therefore, in our wisdom, what we propose to do, Chair, is to deal then with that overview, which will be quite comprehensive for context. And as we say, to preface the other 3 segments that I'll talk about just now. So let's think about it in 4 segments. The overview, extensive, not to be repeated. The second segment, Chair, will be then getting into the charges themselves. And we will explain why we have rearranged the motion, if you like, because obviously we were not going to be guided by Ms. Mazoni's sequencing of the motion. So we've decided to sequence it the way we think will work for you, Chair, and for the process. And so let's call that the second segment. Excuse me. Both those first and second segments are then contained in your first statement that you referred to. The first segment, just to go back a bit, deals with the public protector's understanding of the process, why we are here, the road that brought us here, and so on the one hand. It then deals with, what we might call the nuts and bolts, the Office of the Public Protector. You and I, Chair, we may talk about the Office of the Public Protector, but half of the people don't even know where it is or what it looks like, how many floors are there, what happens when you get an Audi, we just talk about these things. So she will assist us to map that in a nutshell. What is this Office of the Public Protector? And then, of course, we have to, in that process, we'll also be dealing with the person, because again, we can talk about buildings and offices and floors and lifts, but ultimately, this is about people. It's about the public on the one hand. It's about a human being called Busisiwe Mkhwebane on the other. So who is this person? Who is Busisiwe Mkhwebane? What got into her head to apply for such a difficult job, which predictably, knowing that it is strewn with all sorts of landmines and so on, having seen how her predecessor had been treated. I have a story about that. I'll tell you in private, a personal story. Some of us, when we took some of these jobs, you have to tell your family members that, look, it's going to be rough, but hopefully we'll get out of it. And I think I can see Advocate Bauer nodding. You accept them, but knowing exactly what's going to happen. But as they say in the language, it comes with the territory. So that will be, let's call it the other sub-segment to get to understand the person. Then, Chair, we will then deal with some of the broader, without getting into much detail, some of the journey, literally starting from the first reports that she gave to this parliament. 2015-16, you might remember, Chair, that she had the misfortune, actually, I think in her first week, to have to come and present her predecessor's report. Then, of course, 2016-17, she now was reporting her own report, the first one, and so on and so on. 2017-18, 18-19, 19-20, 2021. So without wasting much time, we will give that journey. She, as you know, Chair, devised something called Vision 2023, and we are now in 2023. And so she'll also explain what was that about, how far did she go, where were the failures, where were the successes, and so on. Again, in a brief, succinct manner. Then, Chair, that will then lead us to some of the broader principles. You would have seen in the statement that we have picked up what we call Big Five cases, where we've put 5 court cases. Of course, there are many other court cases, but for the sake of saving time, we've chosen 5 specific court cases that we think, for even a member of parliament who just wants to understand what is this whole thing about. If you read those 5 cases, you'll get the full picture. And they include the famous Nkandla case, where the Constitutional Court explained in very fine detail what this animal is all about. What is this thing called public protector? Why did the founders of the Constitution find it necessary to have such a thing? Why? What was it? Number one. Number two, it takes us to even where we are now, because it says some of the risks inherent in this job is because you're going to be dealing with very powerful people, very powerful forces, and therefore what Chief Justice Mkhwebane says is that it is bound to attract a very unfriendly response from those that you are investigating. So we'll take that. The famous weekly case, I'm sorry, shows my age here. Mail and Guardian. The famous Mail and Guardian case, Chair, that we've spoken about, which says that the public protector is not shackled by by the complaint. If you remember the example I gave to Professor Madoncel, if the complaint is about stealing a car, and in the middle of that, she finds that you also stole a bus and an aeroplane and so on, she will follow that trail, unlike a court of law. Because in a court, if you say, I'm here for the car, then we're here for the car. You can't now, as we go along, add your own things. Yeah. So the Mail and Guardian gives that perspective. There's a SABC case, which also gives that perspective. And then, of course, one of the cases we'll touch on is the fourth of those cases is the Commissioner for SARS case versus Public Protector. Actually, I think it's the other way around. Public Protector versus Commissioner for SARS. That is the case. We'll now be getting closer to the meat, because as you know, 90% or whatever percentage it is of these charges is based on previous court cases. And we will then put into perspective that whole debate we had in July. Do court cases, because they are binding, mean that we cannot inquire, and so on and so on. So we'll have that discussion. And then the last of those big five cases, Chair, is the case of the EFF versus the Speaker. Remember, the first one was EFF versus the Speaker, and the last one is also EFF versus the Speaker. So how we distinguish those cases is the first one is called the Gandla case. The last one is called the EFF impeachment case. So that will be the last case we will be talking about. And I have the misfortune or fortune of having been in almost all those cases, except the Mail and Guardian and the SABC case. But the importance of that last case, the EFF impeachment case, Chair, is that literally it's the one that has brought us here. The rules that govern your committee, Chair, are literally modeled on the rules that emanated from the EFF impeachment case. 95% of those rules are identical. Why is that so? Because Parliament, I think, took the pragmatic view that an impeachment is an impeachment. Obviously, there'll be nuances when you're impeaching a judge or a president or a head of an institution, but the core is the core. And so that case, we won't go too much into it, because except for context again. But that case really set the scene as to why do we need this stage? Because it was believed before that you can just impeach a person, can just wake up and use the Rule 85, I think, of the rules. Speaker Mbete went to the Constitutional Court with that approach, that no, we don't need anything. We've got the rules. You can somehow impeach you. The Constitutional Court, of course, said no, you need to have an inquiry, and so on and so on. Hence, we're here. So that will be the last section, then, Chair. Then after that, we really get into the meat. And the last point I'm going to make about that is the point I've made earlier about the sequencing. We, for reasons that will be explained now, have decided that the first, what really has brought us here are the cases that have touched what the Public Protector calls the untouchables, and which again comes with the territory that was set in the EFF Nkandla case. And therefore, we're going to start with those cases. We're going to start with the CR17 Busasa case, because we believe that it was one of the main triggers for why we're here. Then we'll go to the next level of untouchables by going to the rogue unit Pillay cases. The first case, needless to say, involves the highest office, which is the president of the country. The second cases involve some of the more powerful personalities in South Africa, particularly Minister Pravin Jamnadas Godan. And then, so we'll deal with his cases next. And then when we get to the second statement, Chair, we'll then deal with the next level untouchables. those are the big business, the real rulers. And that will be to do with the CX case, which dealt with the mandate of the Reserve Bank, the economy of this country, whether it should or should not benefit the poorest of the poor, which is the ultimate insult you can give to that level of untouchables. So we'll deal with that. Vrede, we'll deal with Vrede in the same vein. Then, Chair, the third and last segment and the third statement will deal with what we call the HR issues. The HR issues involve, ironically, we think really it's the biggest waste of this committee's time, because it's where this committee is turned into the CCMA, really. To come here, disgruntled employees who are charged for beating up people come here and abuse us. So we'll deal with that really in the end, because we think that that's a red herring. That's not why we're here. I don't think anybody in their right mind thinks that this is the CCMA or the Labour Court. But ironically, the bulk of the witnesses that have been called here involve that non-issue of the CCMA. So we have to deal with it, because out of the 18 witnesses that were called, 15, I think roughly, dealt with the CCMA issues. So that's the landscape there. Then, Chair, we might at the end ask you for an indulgence, maybe to do some kind of wrap up or give the public. I know you're going to give as you've done with all witnesses, you'll give a chance to say her piece, whatever she wants to say, but we might also want to wrap up. Chair, okay, just so that I don't spoil your day, our starting point is that the period, excuse me, that has been allocated for this testimony is too short. We know the issues, you've articulated them, some of them in the letters and so on, but we are very much aggrieved about that. If you had 18 witnesses taking months and months, to expect the public protector to deal with all that evidence when her neck is on the block in 1 week or even 2 weeks is completely unreasonable. But Chair, I intimated to you this morning, we will be engaging with you, the evidence line, just to make sure that that issue doesn't get ahead of us. But we appeal to you to give this opportunity to the public protector. I'm glad. I want to thank you for your opening remarks, because I don't have to lecture you on that. You've just said it yourself. The public protector has been accused unfairly by of people of not wanting to speak or running away if she raises legalities and legal issues about some of the injustices that happen here. The first thing we hear, oh no, she's running away, she's running away. And you're quite correct, Chair. She said, I can tell you this on my word of honor, that if it was according to her, on the 11th of July, she should have been sitting there and telling you her version, because she has been vilified by all sorts of people who don't even know who she is. Some of them have never even met her. And for the first time, she's going to have the time to speak for herself. So if you were minded to give us until December, we were going to use it. I'm just trying to say, Chair, we welcome the opportunity. Thank you very much. So, Chair, if I may then.
Yes, having done that, thank you, Advocate Mpofu. Your name has already been removed there, so I'm going to.
She's now Advocate Mpofu.
I'm going to ask the public protector to follow her name.
Thank you. And may I also follow my name?
Now you have to decide whether you want to be closer to that space or you find the, I leave that to you.
Yes, thank you, Chair. I
Yeah.
think for the, until about tea time, I'll remain where I am. And then if it might be a good idea, Chair, yes, to move one or two desks, but we're here for some time, so it's a long way to December. You'll give us the signal.
I don't want to use the signal.
You just have to say, Al-Kal.
Thank you, Advocate Mpofu. I hand back over to you. We are in your hands. Thank you.
Thank you very much, Chair. Good morning, Advocate Mkhwebane.
Good morning, Advocate Mpofu. Good morning to the committee members, to my family, to the staff of the Public Protector. I know some of them are watching, so I'm here together with you in this process, evidence leaders. And Chairperson, thank you so much. It's cold. I'll keep on. I know possibly you won't switch it off, but I'm not comfortable and I know it's not controllable.
Then Ngozi is attending to it.
Yeah, thank you. Yeah. Okay.
Thank you very much. Yeah. I almost remarked, but
And to members of the public, yeah, who are watching, I think I'm here for you as well. And thank you for watching. Yeah.
yes, thank you. No, I was going to say on a lighter note, I was going to make a remark that the chair is more familiar with. I say it's cold outside of the ANC. But,
I've never been outside of the ANC. So I wouldn't know. Unlike some of us.
It's
I've
very,
never been outside of the
yeah.
ANC.
Some of those will tell you it's very, very hot.
For full 33 years, I've never been outside of the ANC. Thank you.
Thank you. No, thank you very much, Public Protector. We would like to, you heard the remarks that I made, and both the chair and I think have emphasized that this is your stage. It's not the chairperson, it's not me. You are the Public Protector. We are not the Public Protector of South Africa. And you have said, as the chair also correctly pointed out, that you could I just want you really, in your own words, to explain that statement that the chairperson and I have recited, why it is that you could not wait for this day, and why it is that you are so keen to give your side of the story. I think the chair and I watched the same interview, and where you said, for once, the South African public will be hearing from the horse's mouth instead of us talking about you. As the other slogan says, nothing about us without us. So why are you so happy that this day has come?
Thank you, Chairperson. You know, indeed, I'm very much excited that today I will have an opportunity to address the South African public and the world at large, and to my colleagues in Africa as their president. to engage with them and to take them through what actually transpired, because, you know, it's 6.5 years now being the public protector. And I would indicate that I never had peace since I started to work as the public protector. And I think or the cause of all the troubles which you have indicated, Advocate Mpofu, in your opening, touching the untouchables, and I think the real cause being the Democratic Alliance, because as you would know, during my appointment, they were the only party which never supported my appointment. And they were the only party which then after that started with the allegations of me being a spy. And which to this day, they failed to prove, and well, the matter was in court. And also they started in 2017, also then to initiate the process of me coming here. So I think it's good that one is here to just then put things into perspective, and indeed for the public to hear directly from me, because those who have ears will hear, and those who have eyes will see. So, and for them to judge for themselves, because unfortunately, they have been told by the most powerful, well, the media, sometimes manufacturing concern and, you know, portraying a narrative which is so wrong. Indeed, I'm happy, though Chairperson, I must indicate, you'll say the statement is long, but we didn't have enough time because, as you know, we were in court on Monday to deal exactly with some of the issues which we've been trying or have been trying since 2017 to bring to the attention of Parliament, and to make sure that Parliament, as the lawmakers, they indeed comply and, you know, do things the right way, which I will take you through why I am saying that. So indeed, I'm so excited to be here. And I mean, also deal with the wrong perception that I am delaying the process by not, or by raising issues or taking matters to court.
No, thank you very much, Public Protector. I'd like, just as a follow-up, Chairperson, to that, you know, for a case of this size and magnitude and complexity and thousands of pages, for someone like you and me, the question is, where do we start? And they say the answer is usually obvious. You start at the beginning. So I will start a little bit at the beginning, at least of this process, Chair, by reminding us of what we said in the opening statement on the 11th of July, very briefly. It's, Chair, it's just an extract from the opening statement, and it's a lead up. Bundle K, page 13, the bundle, people will tell me where it will be found. We don't have to put it up, but we may.
You got that, Lord Seba? Just repeat that, Mpofu. She's slow today, and more slow.
It's one of those days. Yeah. Okay. No, it's my fault, Chair. I didn't give her the correct. I'll get the proper reference now. But to save time, Chair, I'll just read it in the meantime.
They're also helping you.
Oh, thank you very much. Yes, it will be put up.
Sure.
Item 1, bundle K, page 13. Let's go to, yeah, where I want to deal with, I want to make remarks just a bit. Yeah. Go a little bit up. Yeah. Further up, just so that you move once. Yeah. Further up. Yeah. Okay. No. Down. Yes. Okay. I'll just, that's somewhere in the middle, Chair, where I said at the instruction of the public protector, of course, I want to make remarks about a few high-level issues, Chairperson. The first is to assure you that we're here to participate in this process, that our participation is, however, under protest because of some of the issues that I'm going to highlight, which I have called major constitutional violations. But we're here and we're going to participate, nevertheless, because we represent a law-abiding citizen and public protector. She has always made it clear that she wants the opportunity to assure this committee and the National Assembly, and indeed the nation, that she is fit and proper, willing and able to discharge her duties as public protector. I said, in that process, she has been accused of all sorts of things, including so-called Stalingrad. The people captured it in a way that is objectionable, which is a term that's used by people who hate the Constitution and try and discourage others from exercising their legal rights, which are in the Constitution. Now, that's a very strange accusation, Chairperson, because the irony is that every time when she raised concerns about this process, she has been proven right, every time. The DA and Ms. Mazzoni and all those people who are in the main sponsors of the motion literally have wanted to do the motion, I think, since the day she took office, if not before. And I'll cut some of the activities in 2017, 2018, but around 2019, there was some intense rush to do this. And the public protector wrote a very long letter to Parliament at the time and explains that, yes, we know that Mr. Steenhuisen, not Mr. Steenhuiserman, as it is put there, that Mr. Steenhuisen and others want her to be removed from office. But there's this small matter of the law, and there are no rules that govern the process for such removal, however overzealous it might be pursued. Eventually, sanity prevailed, and that point that you made was considered, and correctly so, because there was at that stage a judgment that the Constitutional Court in relation to Section 89, that's the Nkandla impeachment we spoke about earlier, which said exactly that, in which I appeared to set the principle that impeachment process must have its own designed rules. The Speaker of this Parliament opposed the application and so on. So, Chair, there we were capturing some of the sentiments that the public protector has touched on. So I just wanted to remind us of that. Now, public protector, those were the words, opening words that you had mandated us to preface this committee with. Can you then explain again why you A, participated, and B, participated under protest even at that stage?
Thank you, Chairperson. Yes, I participated, to put this matter to rest. But then maybe let's start from the beginning. As I indicated, that being labeled a spy and the process of then initiating or writing to Parliament. I mean, you read about the long letter which we wrote to the then Speaker, I think, Baleka Mbete, when the DA, after the CX judgment, and whilst after the Gauteng High Court judgment was delivered, then they initiated the process to start saying, I need to account, I need to be removed. I don't know the law. It was all that hullabaloo actually in the country because, again, touching the untouchables. Then there were various stages which this process took place, because the then members of the DA, I think it was the start of initiating or wanting to initiate the process. They wrote to the speaker. The matter was dealt with by the portfolio committee on justice originally. That's when they indicated that they wouldn't deal with this matter. This matter should be escalated to the speaker. And, you know, Chairperson and Advocate Mpofu, that's where I wanted this process to be as fair as possible, because at first, remember, they were focusing on me as the public protector. Then later, there was a stage where they were saying, no, it's for all members of the Chapter 9 institution. But then firstly, they initiated the process. And I said, but you cannot go ahead and initiate such a process just directly from section 194 of the Constitution. You don't have rules on how this process will be ongoing. But secondly, as well, you cannot communicate every decision which you are making with the media without engaging me. So when you say all the time they were proven wrong, it's because when I spoke about the issue of the rules, then there was that process where they started deliberating on the matter at the committee level, and the committee then said, no, they cannot deal with this matter. It should be escalated to the office of the speaker. Then the speaker initiated the process that there should be drafts of the rules. And then that's where the rules were drafted, but those rules as well were, it was just a matter of cut and paste, because there was a rush on removing Advocate Busisiwe Mkhwebane from the office, because being labeled all sorts of names. Then I had to initiate that process. And indeed, they drafted the rules.
Thank you. So just to make sure that understand that. So from you're saying from about 2017, the DA wanted you to be removed. And it took you and Chairperson, that letter, the long letter she's referring to is dated 5 July 2018. I was not able to establish this morning if it's already on in the bundle, but for current purposes, it doesn't matter. We will upload it in due course, because we're not talking about the content really, we're just talking about its existence. So it took you, the person who doesn't know the law, to advise the Parliament of South Africa that you cannot actually do what the DA wants to do. You need to have rules. And as you say, sanity prevailed, and it was then understood that the process of rulemaking must be done. Right. Then that process then started. Then what happened next?
Yes, as I indicated that the 5 July 2018 letter, then the speaker referred the matter then to the committee. There were various deliberations. It was not only one meeting. I think it would be several meetings, because I think the process took another year to a year, 18 months, deliberating on this matter. Then there was a stage where Mr. Steenhuisen then again writing to the speaker, indicating that we have the draft rules. Hence, I'm saying that was a cut and paste from the original rules which were drafted by Parliament
for the president.
For the president, yes.
Or others, for the impeachment of a president.
Of a president, yes. So then those rules, the way they were drafted, also they were very much questionable. Because after the drafting of the rules, then we were never given an opportunity to comment on those. I will say we, because remember the allegation was it's for the Chapter 9 institutions, and Chapter 9 institutions, for the benefit of South Africans, are the institutions: Public Protector, Auditor General, Gender Commission, Commission for Religious and Linguistics,
ICASA.
ICASA, and Human Rights Commission, and the IEC.
Mm.
Then I would say we, because we have this forum where I also sit as the Public Protector of a Forum for Institutions Supporting Democracy. So the question was, but this cannot proceed as is, because these rules, I remember even originally it was even including the fact that a member or the head of the Chapter 9 institution might be removed, and you were never given an opportunity to present your side of the story. And I remember one of them being concerned that, I mean, they would say, even when you are incapacitated or you are sick for a longer period, you will just, it was like being summarily removed. The worst part, those rules also didn't include the issue of legal representation. I think they were drafted in such a way that it covers the Chapter 9 institutions. But as you go through the letters and the communications from the DA, you'd see that those rules were drafted specifically for me, because there's where in the letter where it says for the removal of the Public Protector. And that's another issue of the removal, because this process shouldn't be for the removal. This process should be for the determination of the fitness to perform your responsibilities, because remember, again, that is still a process. You cannot just, in a constitutional state, just speak about the removal. And I think that's what I've picked up in this committee when they are reading the people for them to take an oath. You know, they will just say the committee for the removal of the Public Protector. It's not a committee for the removal, it's a committee to determine fitness. Because then if you allow yourself to be labeled that, it means, which I've been saying, or we've been saying, that sometimes I feel as if it's a predetermined process or an outcome. So then after that, the rules were drafted and they were presented to the Speaker, now the 6th administration, Ms. Modise. Then there was that announcement of, Mazone submitted a motion, and the Speaker then announced that they have this motion from Mazone.
Yes, just on that, thank you. So we're now, just to situate it, Chairperson, it's common cause that the rules were passed on the 3rd of December 2019, and the motion, which we now know as the Mazone motion, was generated, sorry, I almost said manufactured, was generated within 72 hours of the adoption of the rules. And on the 6th of December, it was put through. Okay, all that is common cause Public Protector. But just as a matter of interest, you talk about a historical unfairness. Can you just share with the Chairperson and the public and the members how you even got to know about that Mazone motion and how it was processed?
Unfortunately, I discovered, or I found out from the media, the billboard story we were discussing earlier, because I just had the Speaker having issued a statement indicating that there is this motion and it's presented and it's adopted. And that's when further writing back to the Speaker and informing the Speaker about the process and the unfairness of this particular process.
So are you telling the members of the public and the committee that nobody even bothered to just forget about writing, just a phone call or whatever, to say, we have a motion here, it's about you, and it has been processed?
No, not at all, because remember, I'm accountable to Parliament on how I use the state resources on the issues of overseeing and performing my responsibilities. I engage a lot with the Justice Portfolio Committee. But besides that, as the Forum for Institutions Supporting Democracy, we engage with the Speaker, and there's an office within the Speaker's office which should be engaging with us regularly. But unfortunately, that was not the case. And I only I discovered when that statement was issued, and I had to then write back to the Speaker. And yeah, that's when we will be dealing with the letter of January 2020.
Yes, all right. So, okay, and the statement you're talking about issued by the Speaker was the media statement?
It was a media statement.
To the public,
Judge,
okay,
yes.
not to you. All right. Okay, Chairperson, again, that's common cause that statement was dated 24th of January, which was a Thursday, I think, if I remember well, because I spoke to the public protector, I think about 24 hours or 48 hours later. Okay, so you see the billboards or the headlines, and of course you then contact legal representatives, and who did not sleep for that weekend. And then on the Monday, the 28th, you caused your legal representatives to write a letter to the Speaker responding to these newspaper headlines. Chair, if I may, can we go to page 660 of the statement, of the Public Protector's statement, which Tsepo will tell us, I think it's bundle H, item 31.7, page 660. It was uploaded last night, or maybe. Okay, oh, you got it. Okay, thanks.
Advocate Mkhwebane, when you give the page numbers on the top, can you also give the type page numbers at the bottom? Because SEPA's having a problem with the top numbers.
Bottom of what? Of the page number?
Yeah.
No, unfortunately, this is not, it's not the body of the affidavit, it's an annexure, so it doesn't have a. So go to, okay, let's do it like this then, Tsepo. If you go to the very last page of the statement, the typed statement is 154. And then you'll have BM1, BM2, this is BM3, it's 4 or 5 pages after the 154.
What was your number?
154 is where the Commissioner of Oaths has signed, the last one. And the Commissioner of Oaths signed every page, by the way, yeah. But yes, but so that's the last page where the full signature of the Commissioner of Oaths, and then it's 4 or 5 pages of that BM3.
Let's see if Sloan Tsepo is winning.
So Public Protector, while we are waiting there, just to make sure that you didn't amend this affidavit afterwards. You didn't commit forgery.
Advocate Bauer, the mic of Advocate.
Please switch off your mic. Thank you.
No, I didn't. And I think it's very important that we just hold or respect the decorum of this house and make sure that we treat it as such, because I've taken an oath and I need to make sure that whatever I say is not changed after or somebody else, because if we allow that, somebody else can even change my statement or include things. And I think it's just to protect the integrity of the process.
So thank you. No, let's not go there. I was just waiting for Tsepo to We'll get to that January at the appropriate time. Yes, so Chair, on 28th February, I'm sorry, 28th January 2020, that's the letter. So again, you, the person who doesn't know the law, within 3 days of reading these headlines, you again advise Parliament about its illegal ways. We want, it's a longish, it's not that long, but it's not longer than, rather, it's shorter than the previous one, which was, I think, 25 pages. This one was only 7 pages, Chair, because I was involved in its writing. So your shorter letter, then say that paragraph 2, I'll just read extracts. Our client, this is from Sianeho Tennis. Our client is aware that the rules of removal of office bearers in institutions supporting constitutional democracy were adopted on 3 December 2019. And having sought and obtained legal advice, she's of the firm view that these rules are unconstitutional and unlawful, as they amount to a violation of the constitutionally prescribed duty to protect the independence of Chapter 9 institutions. Neither do they adequately provide for aude alteram partem at all in their application and implementation. All in all, the rules are fatally tainted by irrationality and several other breaches of the rule of law. Okay, let's jump to you raise the issue of the involvement of a judge in a process like this, that it was unconstitutional. And then let's jump to paragraph 6. That was an important one. Another advice, free advice from you to the Parliament. You say even on the DA's version, allegedly occurred long before the adoption of the rules. This purported retrospective application of the rules is in flagrant violation of the rule of law, including the time-tested principle of nulla poena sine lege. And for those who don't know Latin, it simply means there is no punishment without law or without rules. You can't, it's obvious. You must first have a law, and then you must and then you refer to section 1813, we spoke about that. And then you talk at paragraph 9 about pronouncements made by Dr. Matole Motshekga in the committee, which showed that he had preempted the process by referring to your competence. And then you quote at 9.2 Rule 88, which Mr. Motshekga, Dr. Motshekga, sorry, had breached. That rule says no member may reflect upon the competence or integrity of a judge or a superior court, the holder of a public office in a state institution supporting constitutional democracy referred to in section 194 of the Constitution, that's a person like you, or any other holder of an office other than a member of government whose removal from such office is dependent upon a decision of the House. It's obvious why there is such a rule. And you say that that rule had been breached. Then let's jump to the issue that you've just spoken about now. You say, notwithstanding all of the above, the National Assembly has unlawful, paragraph. Standing all of the above, the National Assembly has unlawfully and out of the blue issued a media statement on 24 January 2020, stating that the Speaker has approved a motion brought by the Democratic Alliance and thereby purporting to initiate proceedings for the removal of the public protector. Our instructions are that our client has never ever been accorded the courtesy of being informed about the initiation of this process aimed at her removal from office, let alone being invited to comment thereon. She had to read about it in the media, all in the name of fairness, justice, and Ubuntu. And then you say to the speaker, you remind her of what was said in the EFF as the speaker matter, that's paragraph 19, that she, of all people, should know that this is illegal, because what was said in that case was the following, paragraph 55, which is, I think, was high expectation from the judges. It says, although all members of the National Assembly are expected to know the rules of the National Assembly, there is an expectation that the Speaker would know the rules of the National Assembly better than everyone else. And you then said, you please kindly furnish us with a response. And I don't have to bore the committee with the response. The response was dismissive. No, there's nothing wrong with the rules. Go do whatever you want to do. All right. After that, you then did whatever you had to do. What was that?
I think before I say that, Chairperson and SC, because that communication was also trying to say, can we talk? Can we engage on these issues? But yes, it was a dismissive response. Again, going back to those delaying tactics, which I'm blamed for to this day. I was trying to make sure that there's no need for us to go to court because litigation is very expensive. But unfortunately, or again, fortunately for South Africa, is that this constitution is, protecting everyone. Then we had to take the matter to court because we showed them that, and especially in this letter, the issue of not complying to the rule of the Audi Altaramparten rule. I mean, giving us as Chapter 9 institutions an opportunity to comment on those rules. Secondly, the issue of retrospectivity. That is so wrong. In law, you cannot do that. That you will then have to persecute a person with the law which you've recently crafted. And I think that's what we also told them, you cannot do that. The other issue then was the issue, I don't remember whether we've included the issue of the legal representation, because the rules were saying, no, you cannot be represented, you are legally qualified. But the fact of the matter is, if the rules were not meant for me, what about the other Chapter 9 institutions? Because your Human Rights Commission, well, even your Gender Commission, CRL, they are not legally qualified, those heads of those Chapter 9 institutions. So we had to take the matter to court, all the courts which are there as well, to make sure that there is proper interpretation of what the Constitution and the law is saying. So then the matter was taken to court. If they listened by then, I mean, if you could check, one SC used to say, I mean, counting how many court cases have been to court, as if it's anything wrong. But again, it was trying to bring sense to the lawmakers that they didn't want to, they delayed. Well, finally we had rules, but your rules are so unconstitutional. No, we are proceeding. Then we took the matter to court. And indeed, the court found in our favor to indicate that, yes, you cannot involve the judge. Yes, you cannot. It was the issue of legal representation. So again, we were vindicated, but unfortunately then the narration that is perpetuated by the media, because they've always been there, especially mainstream media, instead of reporting properly, educating, making sure that whoever is a South African is properly protected and understands they understand what this process is all about.
Mm.
And I must say, SC, that I think I understood that, you know, sometimes somebody has to do this or being used as a sacrificial lamb or as, you know, so that this process can be tested. And I'm always been saying, it's not for me. It's for my successors or the generations to come, because we pride ourselves as a country that we have this constitution, the rule of law. But then are we walking the talk? Are we implementing it to the T? And indeed, we took it to court, and the court, again, we succeeded.
Good. Well, that's not what was reported, but for some reason, I'm here now. So I think we did succeed in the in getting you legal representation. Yeah. Okay. Now, I think from what you've just said now, it's important once again to say, because you started by reminding me that these letters were not in the spirit of fighting. It was to say, let's talk, let's not waste taxpayers' money, let's not go to court. These are the flaws in the rules, look at them, and then let's have the impeachment tomorrow if we're going to have it here. But you are forced to go to court. All right. So then you touched on the issue of retrospectivity, which is another advice you are giving to Parliament. And maybe it's time to say something nice about the DA, because the DA looked like it had better lawyers. Yeah. We know that the Parliament said, no, there's nothing wrong with this. But I think the DA said, no, there's a problem. What then happened around the issue of retrospectivity?
You know, they then realized, because at the end of the day, whatever one was advising them on, again, showing that, you know what, do things in a proper way, because if I was somebody else, I would just come up with all the wrong advices, because I said, you cannot apply the rules retrospectively, because it was relating to your sub matter, Reserve Bank matter, the Freedom matter,
CX,
the CX matter. And those matters were still before court, and already there were judgments on those matters. Now what they did, they realized that, hey, this is not going to work. Then Mazone withdrew that motion because they realized that it's not compliant to the law, as we are indicating.
You mean Honorable Mazoni?
Yes, Honorable Member Mazoni, Miss Mazoni, yes. So then they withdraw that, and she was the chief whip of the DA. Withdrew that, and within 72 hours, I think, 3 days, they filed a new motion. I'm not sure whether it was 3 days or...
No, it was on the same day.
Same day.
In the morning, it was
yes,
withdrawn.
in the afternoon, it was withdrawn. And unfortunately...
72 minutes, maybe.
Unfortunately, then for the speaker again, instead of also possibly engaging or those who are advising her legally, saying, but you cannot just admit another motion, because they had to find a new issue, and that new issue was possibly being in cahoots with Samuel, because then there was that letter which Samuel wrote to the speaker.
I'll take over from the chair. You mean the Mr. Sipelo Samuel, the second witness, when you say Samuel, okay.
So then he wrote to the speaker complaining about being persecuted by me. And by then it was when he realized that I am aware that he assaulted, or we were being sued as an institution, he assaulted a complainant. And that process was the process when I was saying to legal services and the CEO, this is a very, we can't be seen to be doing this. So then the Honorable Mazon, Chief Whip, withdrew that and filed the new motion with those issues of someone. Those were the only new things which she included. But the fact of the matter is those cases were still matters which happened before the rules
Yes.
came into.
No, fair enough. So, okay, so this was I mean, unless if you're I don't know, 2-year-old child, it was then a clear, at least quiet acceptance of the fact that you can't have retrospective rules. So they had to find a new issue, being Mr. Samuel's so-called affidavit, if we can call it that. Yeah. We've seen some affidavits in this process. All right. Okay, so at least, as we say, the DA saw the light and then they manufactured, quote unquote, or generated the Samuel complaint. Fine. And then they withdrew and replaced the motion with the speed of light. Fine. So that motion then was submitted, Chair, on the 24th, I think, of February. Okay. Then once again, you were faced with a so-called new motion. And then, you, as you say, you went to court, you were forced to go to court, and then the court, at least the High Court here, upheld 2 of your objections, which was the involvement of judges and the lack of legal representation. And once again, the DA, I don't know, like praising them like this, but once again, the DA had better legal advice than Parliament. So the DA then did not appeal against the finding of the Western Cape High Court that you should get legal representation. They only appealed on the other issue of the judge, involvement of judges. But our Parliament of the people fought to the bitter end, up to the Constitutional Court, to say you are not entitled to legal representation. What happened?
Yes, I think again, being a concern that the advice to the speaker and especially the lawmakers and the ones who are also supposed to be overseeing how the various legal or legislative frameworks are being implemented and also saving the resources of the state. They appealed that. And again, normally I would say it's as if I don't have rights. I must just be left out to hang. And the worst part is that the very same Parliament where I am accounting to, especially always with the annual reports, going there, reporting how one is working. There was nothing stopping them or even the speaker through this office of the office supporting institutions, supporting democracy, to say, come, summon me, sit down. Why is this happening? Why can't this be done? Unfortunately, then they were opposing that I get a legal representation. So, but thanks to the Constitutional Court, again, they brought sanity to that issue that, you know, even a hardened criminal, a serial killer, serial rapist, when they say, I want legal representation, they are afforded that particular opportunity, irrespective of whether this is not a criminal case. But the fact of the matter is they are dealing with the rights of a human being. You know, my mother used to say, "Ngingumundu nami." You know, mundu. Yes. So yes, I think sanity prevailed and we are here.
Thank you very much. Right. Then the Constitutional Court, in a judgment of, actually a unanimous judgment of the Constitutional Court penned by Justice Mkhwebane, then said that you should be accorded not just legal representation, but full legal representation throughout the process. Right. Okay, so again, so you advise them about the rules, they did the rules, but they did them wrongly. You advise them that they've done it wrongly, then they went up to the Constitutional Court and then they lost. And so now the Constitutional Court actually had to itself amend the rules, particularly the rule 129 AD3, which is the one that said you should have a lawyer who just sits here and says nothing. Right. Fast forward. Then the rules have been cured by the Constitutional Court, thanks to you. And now we are theoretically ready to go. Again, you had to, once the judgment of the Constitutional Court came, it came on the 4th of February, Chairperson, 2022. And Chairperson then gathered his troops. On the 22nd, 20 days later, the troops, and I say that without any disrespect, including Honorable Ngola, the troops were gathered. And it was said that, oh, well, now we can start. The Constitutional Court has told us about the legal representation.
That's in reference to the 36-member committee that I chaired.
Yes, another correction, Chair. Yes, otherwise known as the troops. Thank you. That is the 36-member committee of honorable members. Yes, Chair. Right. So that committee then met on the 22nd of February and decided, okay, well, now there's a Concord judgment. Let the games begin. And I'm also just rushing through the common cause stuff, Chair. If I'm putting words in the mouth of the witness, Advocate Bauer will say so, yeah. Then we, after the 22nd, the committee then said it was going to finalize its terms of reference.
Just a pause, Advocate Mbofo, Advocate Bauer.
I'm not going to unduly interrupt, but let's not assume that everything is necessarily common cause.
No, that's exactly the point I'm making.
No.
If I stray into
No.
something that's not common cause, then please.
But Advocate Mbofo, I may just leave you to say what you want to say without taking issue, even if it's incorrect, and then pick it up with the witness when it's
Later.
our turn,
Fair enough.
rather
Thanks.
than seek to interject. All I'm suggesting is, if I'm not raising an objection, don't naturally assume it's common cause.
No, I don't. I think I'm addressing a different issue. I'm saying I'm not necessarily that it's common cause, but I'm saying if I put a leading question or if I give evidence, as it were, about dates, if it's common cause, then unless if I stray into disputed stuff, then please raise it here. Okay. So
You just put back your mic. Thank you, Advocate Mkhwebane.
yes, thank you, Chair. Yeah. So I was just, I think the Chair understood, saying that yeah, if I fill in dates and so on, unless if it's contentious, right? So I was saying, okay, then the committee meets. The committee, this is all common cause. The committee decides that it must adopt terms of reference. The committee decides that at some stage it will be appointing evidence leaders and so on, all well and good. Because the committee had been suspended, well, let's put it, had voluntarily suspended its work.
That's very correct. To put it
Yes,
that way.
the committee had voluntarily suspended its work at the advice of acting Speaker Tsenodi, who really has been probably the best voice of reason throughout this breath of fresh air. When they were waiting for the Constitutional Court judgment, he advised the Chair, and the Chair agreed. I don't know if he agreed willingly or kicking and screaming, but he agreed to suspend the process. Right, and then it was then unsuspended duly because the Concord judgment was out. Okay, so, and Chair, I'm doing this really also to help other people who are not familiar as you and I with the process, just to fill the gaps. Anyway, that's fine, that's February. Come March, the 10th of March, the Speaker of Parliament writes to the President and says, the committee started on the 22nd, blank, 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 without saying what that letter was for. And then on the 17th of March, the President says, oh, I got this letter. Tell me why I should not suspend you in terms of 194.3A. Then again, you write letters, let's not go to court, let's be amicable, and so on and so on. Rejected. What happened next?
What I would say is that, I mean, you're raising the issue of the Deputy Speaker. Normally, the Deputy Speaker is responsible for supporting and overseeing the operations of the constitutional institutions, especially Chapter 9 institutions. So I must indicate that I think even the other Chapter 9 institutions had, when they met with him, they raised their concerns and the challenges. I think that's when he also realized that, I think, you know, let's just focus on what the law is saying. Let's allow the process to be taken to court. Let's wait instead of just proceeding as if there's no tomorrow. So then, indeed, then the Speaker wrote to the President, and then the President started the process of writing to me. I think that was what triggered the letter which was written by the President. So, and I think the previous Speaker, Ms. Modise, Honorable Modise, well, he was the Honorable Modise, member of the House. Chairperson is calling me to order here. Well, who is going to call me? But then they wrote informing the President of what is transpiring. But then the second letter by the Honorable Speaker, Mapisa Ngagule, then was like, now it means we can, in a way, start the Section 194 process. So that's when then I received the letter from the President asking why I should not be suspended or give reasons for that. Then the process started again, where we wrote back to the President, trying to show the President that, okay, let's engage on these issues. Again, the Speaker, can we communicate on these issues? But that fell into deaf ears again. What else to do? Go back to the courts. I think there was then part A of our application where we were trying to interdict the process. And I think interdicting the process, again, it's not an ideal process, but I think if we can reach a point where issues are deliberated on, we agree and avoid state organs litigating against each other, because at the end of the day, it's the taxpayers' money, and that fell into deaf ears, and then we had to go back to court.
Thank you. Yes, again, to speed things up, you're right.
Maybe just before you proceed to
Yes,
us,
Chairperson.
I want to take a break, but if I don't, I'll be in trouble, and you know from where I'll be in
I
trouble.
know, Chair. I know.
Oh,
I support you, Chair.
I want us to take a 10-minute break. We'll resume after 10 minutes.
Thank you, Chairperson.
Thanks.
Recording stopped.
colleagues. Just before I hand over to Advocate Mpofu, just to emphasize this traffic issue. So every time we have a physical witness here physically, I want us to avoid the traffic unless you have to. So I give regular breaks. So, and the culprits know themselves, and they will be named soon. So let's avoid the traffic. Thank you. Over to you, Advocate Mpofu.
Name them, Chair, name them. Thank you, Chairperson. And Chair, I hope you can also help us on the issue of temperature. There's culprit next to you. It's cold.
Okay.
Um,
Okay, I'll continue. Is that
okay,
being
no, it's bearable, but it's okay.
Thank you.
Thank you, Chair. All right. If it's too hot, you know what to do.
Yeah.
Yeah.
Private sum.
Private summer. Thank you, Chair. So okay. I'm just wanting to finish that journey of your series of, let's call it legal lectures. So first, you advised that there should be rules. There were rules. Second, you said it was retrospective. They changed it. Then you said it needs legal representation. The Constitutional Court came to the rescue. And now we're now on the fourth level. Then you say to the president, no, you can't do this. You can't just suspend. For this and that reason, let's talk. Let's find a way. In fact, you started with this committee. Please stop your proceedings because we're challenging the suspension. The usual happened. No, we'll go ahead, which is then took us to what you call part A. Then we get to part B, where you were now saying that the suspension of the president is unconstitutional. And by now, I think we know the drill. What happened? What did the court say? Did they agree with you or did they disagree with you?
Let me say that the committee proceeded. Indeed, we requested them to stop the process in the meantime. I think there were those deliberations where they were saying no, the processes are not linked, which they are very much linked. So we then challenged the president's matter, and the president went ahead to suspend. I must indicate that the unfortunate part is that, again, the speaker wrote the letter in March, and there was then a complaint which was lodged by the ATM relating to the famous Farmgate scandal or the Phala Phala matter. And again, coming back to that issue, which most of the time, I mean, I was invited by one church in Delmas and engaging them, or it was women on issues of, so another one asked genuinely that, you know, we are told by the media that you are fighting the president. And I had to then break it down to the person to say, I don't know how many times one has indicated that this constitutional institution, going back to the Mkhwebane judgment, that you will be fighting the most powerful, and people will feel embarrassed, or those powerful, or as well people losing face. So a complaint was lodged, not to say it's me who then went all out to say, hey, bring the complaint. And that complaint is very, again, unique, because not any member of the public can lodge a complaint against the president and in terms of the Executive Members Ethics Act. So the complaint was lodged by the ATM, and I think it was a matter of 2 days or 3 days, the complaint was lodged. A letter was then written to the president to ask questions, especially to start collating the information, because
So that just for perspective, again, those who are following the sequential, the complaint of the ATM, its common cause was lodged, I think, on the 1st of June last year, 2022. And your letter with 31 questions to the president was written, I think, on the 7th of June. But you've said that you didn't invite the complaint, it came to your office and you acted on it. Okay. And take
I
it from
acted
there.
on that complaint, being the Executive Members Ethics Act,
Mhm.
and which is very prescriptive that the complaint must be finalized within 30 days. Though we've been struggling several times to do that.
Mhm.
So then we wrote, actually the matter was allocated to one of the very senior investigators or chief investigator to then start preparing the questions, the first audit. Because then any complaint which is lodged, we have to inform you there is this complaint. Can you supply us with this information in the meantime whilst we conduct other investigations? So then that's when the famous 31 questions were crafted. They were sent on the 7th of June. And I think on the 8th of June, I confirmed, because normally media will come with questions to ask. We hear that there's something like this. And then then I confirmed, or we issued a statement confirming. It was basically that, not to say
On the 8th.
on the 8th, not to say going all out and say, hey, Pella, now we are having this, which is not what we do. Unfortunately, our work is in such a way that media will have a lot of interest in. And we have to work with them because they are a key stakeholder, I must indicate, and we have to respond to them and, you know, and be transparent, because that's what our constitution demands of us. And then unfortunately on the 9th of June, I then, actually I saw it on the news again. I was with my grandson and he was, I think, around 2 years by then, and he was saying, Coco, you know, they were showing my picture on TV. So now when I saw it, and I was like, oh, public protector suspended. Well, I couldn't tell him because we were only the two of us in the house that, hey, I'm suspended. Yeah, but that's what transpired. Again, the same issue. No one called me, no one warned me. Can you expect this? I've already decided. And I mean, our issue was we were in court, my legal team agreeing with the legal team of the president that they will give us heads up. That never happened. But then be that as it may, then I received the letter. Well, we saw that the letter was sent around 3 or 4 in the afternoon. And by then the president was appearing before Parliament. So when that happened, then we were very shocked because then there's something like this, the suspension, and we took it to court. Actually, there was already part A and part B of the court process. So remember, we were interdicting the president that you cannot proceed with the suspension. There's several issues you need to take into consideration. And we were also then still guiding that, but there are various number of issues which you need to consider. Remember as well, the matter was still back to the Constitutional Court on the issue of rescission. And besides that, it was also before court when we raised new issues of the leakage. I think.
Yes,
Yeah.
that's correct. And we are still on the 9th, yeah. And on the 10th, we had been informed that there'll be a judgment on part A.
Yes, we were informed that there will be a judgment on part B. Remember already, it was already, in fact, it was part B. Remember, because the comments by the full bench was that the conduct of the president was
No.
rushed.
And that was in September later on.
Yes.
On the date of the your suspension, the following day at 8:30, we had been informed that there would be the judgment on part A, which
On
was
part A, yes.
whether or not there should be an interdict.
Oh, yes.
So what is the significance of the fact that there was going to be a judgment on the following day?
Oh, yes, yes, there was that judgment on the 10th, and all the parties were informed that they will be delivering a judgment the following day. But then the president went ahead the day before that, couldn't wait for the court. And that's what we also showed, or as well reasoned with the legal team, or as well, trying to show the courts and even the legal team that was rushed. And it's like then he preempted the decision of the court.
Yeah.
And there were other issues which transpired after, which showed that there was something which was done, because it was as if the president was not even respecting the courts, preempting the courts after being informed that the judgment is going to be issued the following day.
Right. Okay. Right. Okay. So there it is. The president then suspends you, even though on the following day, the very issue of whether that suspension is lawful or not was going to be judged upon by the courts of South Africa. Fine. So after that, you then instituted Part B and included the issue of the suspension. In the meantime, this committee was apace, and it said that it was going to start on the 11th of July, right? And the members of this committee now will get into gear with us, because Chair, you'll remember when we were here then on the 11th, we then asked, can we be excused in the next 2 days or 3 days or whatever? And that was the hearing of Part B of that application, which was the main challenge, no longer the interdict thing now. The main challenge on the president's constitutionality of his powers to suspend you, right? So that was heard in July in front of 3 judges. That judgment came on the 9th of, just fast forwarding.
3 months.
Yes, on the 9th of September, then that judgment came out, and that, I think you were going there. What did that judgment say on the 9th of September about the president's suspension?
Suspension. I think before we go there, I think one thing which I would say, some of the information fell into, well, the speaker listened on some of the issues, which is the issue of the panel. Actually, that comes in, and I just want to mention that when they were deciding on which panel members to deal with determine the prima facie issues, I remember we utilized advocate in SABC before for a legal opinion on the issue of the funding or the raising funds for the personal costs. So the speaker wrote to me and said, we intend to use or to have this person as the. So I'm just saying, at least somewhere they were listening, and if that could have been done regularly, we wouldn't be going back and forth to courts. But then again, coming back to the issue of the Western Cape High Court, the 3 judges or the full bench, where then the court indicated that it was in their view that the suspension was hurried in nature.
Sorry, I'm sorry to interrupt you, Public Protector. Just to assist the members, the chair could go to what the Public Protector is now quoting, just for the benefit of the members, page 521 of that statement, which is page 25 at the bottom, Tsepo. That's where the full quote of what the gist of what the High Court found.
You there, Tsepo? Okay.
Yeah.
Sorry, Public Protector. I just want to, as I say, kill 2 birds with 1 stone, so that when we get to this part of the statement, then we don't have to deal with this. Could you maybe read for the record then, paragraph 155, you'll see that it's put there cryptically. There's a fuller version, but 157 is put in full. So if you have the real paragraph 155, you can assist by reading it out and then read 157. Sorry, Chair, in the rush to do the statement, we didn't put those words in between there, but that judgment, I think, is already part of the record. All right, just deal with 157.
And then we will come back, because
that was the gist of what the court found in your favor.
Paragraph, yes. In our view, the hurried nature of this suspension of the applicant in the circumstances, notwithstanding the fact that the judgment of the full court was looming on the 10th, and that led the court to a conclusion that the suspension may have been retaliatory and hence unlawful, and it was certainly tainted by bias of a disqualifying kind and perhaps an improper motive. So it was in their view that the president cannot bring an unbiased mind to bear in the circumstances which as he was conflicted when he suspended the applicant. So that was then the key issue which the courts indicated. And I think there's paragraph 155 of the same judgment, which I'm saying we should have also captured there in full, which I was trying to open now, which I also, yes.
Yes. Chair, for the sake of progress, I'll just read it into the record. And the members can, so in other words, I'm going to read the dotted lines as well. Yeah. It says, significantly, as indicated there, significantly, the sequence of events leading to the suspension of the applicant cannot be discounted or overlooked. As explained above, on 7 June 2022, the applicant informed the president in writing that she was instituting an investigation against him with regard to allegations relating to a violation of the Executive Ethics Code. Mr. Nwala's special. In respect of the Pala Pala farm incident, 31 questions were raised and the president had to respond thereto within 14 days. This correspondence was followed by a public announcement by the applicant on 8 June 2022, as the witness indicated earlier, that she had decided to launch an investigation against the president in respect of the Pala Pala matter. In response, on the 9th June 2022, the president decided to suspend the applicant. On the objective facts it is reasonable to form the perception that the suspension of the applicant was triggered by the decision of the applicant to institute an investigation against the president. There was no other plausible or logical explanation for the premature suspension of the applicant on the eve of a judgment meant to determine the very lawfulness of the suspension. So that was paragraph 155, and then 157 you've already read out. Right. Then, just for the record, Chair, I'm told that case is in bundle H, 31.3.2.14, and we had raised it in the context of the Sokoni evidence. So it will be in the Sokoni folder. Thank you, Chair. Right. Okay. So now the court says effectively on the 9th of September, more than 6 months ago, your suspension was unlawful. You can go back to work, and you were very happy, understandably. And then what happened next?
And that never happened because the DA, again, within 24 hours, I think it was within the same day, then wrote a letter to indicate their intention to appeal that judgment. And then I couldn't go back to the office because I was ready to go back to the office and continue to do the work which I am always, or I'm being paid for, and which I enjoy to serve the public and the poor and the marginalized. So actually that's what I am appointed for. I'm not appointed to deal with these 5 cases. So this, because it's based on this impeachment. So that application then was lodged, and the president also joined as well, and lodged the appeal. And it was well, from our side, we then also lodged an appeal. In fact, we a section, Rule 18 application, if I'm not mistaken, to say we would want the decision of the court to not be affected by the appeal. So then that matter never then succeeded. Where the 3 judges then agreed that the matter should be taken to the Constitutional Court for confirmation of those some of their order. So we are here, still appearing before the committee, and we have argued that matter in November 2022. So we're still awaiting the judgment in the matter.
Right. Thank you. So that matter then, where you were reinstated effectively to go back to your office, and then the DA and the president appealed, quote unquote, so that you should not go back to the office in the meantime, and was argued on the 24th of November, and we're awaiting judgment eagerly. All right. So if that matter is successful, then obviously the Constitutional Court would confirm the High Court judgment, and hopefully the following day you'll go to the office. I know that you are waiting for that judgment eagerly. But Chair, just on a lighter note, on that day, the 9th of September, the judgment was handed down in the afternoon. And if it had been handed out in the morning, as it normally happens, the public protector would have gone to work to receive a memorandum because there was a march to her office by the ATM and others. What was that march about, public protector?
That was relating to the very same issue of Pala investigation and the delay to finalize the matter. So as I said before that, we try our best to finalize those matters speedily. And that is done not besides the issue that the emir is providing for 30 days. But the fact that the very same accusations against the person who's being accused, it helps to get the outcomes quicker and deal with the matter speedily. So I think the main issue was we've lodged the complaint, the violation of section 96 of the Constitution, which then also provide for the Executive Members Ethics Act, how the executive should conduct themselves. And I think it was an issue of how you update the complainants in the matter and whether the matter would be finalized speedily. I mean, I'm saying this because I remember around 2017, when I was appointed as the public protector, when I was visiting provinces, in each province meeting the premier, then being hosted by the speaker, because we normally, the speakers of each province are our key stakeholder, because remember the speakers also hold the executive to account. So normally we will then work with them. Then the then Premier of Eastern Cape, Mr. Maswale, was saying, PP, one thing which I would urge you to do is that if there are complaints lodged against members of the executive or even any or any public servant, if you can just find it in your heart to make sure that complaints are dealt with speedily, because you find that a person is accused, the media run with the story over and over, and people end up believing whatever you are accused of. And if you can investigate speedily, that can be then dealt with immediately, because some people will even lose their jobs. Some will be labeled that they are corrupt without any detailed investigation. So I think then also when I joined PPSA, I discovered that my predecessor appointed one of the senior investigators who was specifically appointed to deal with executive members' ethics complaints. Mr. Kok is now based in our Gauteng office. That was the intention, to make sure that especially EMEA matters, but we comply with the law, but on the other hand, whoever is being accused, their matters are dealt with speedily. So that's where we've been striving to make sure that we deal with matters speedily.
Good. Thanks. Okay. So, right, no, that's true. So then the Pala March of 9th of September was informed by that. Well, 6 months later, they're still waiting. The report is still not out. But be that as it may, or let me say 9 months or 10 months later after your suspension, that report is still not out. But let's put that aside. The EMEA, I think that it's common cause, and it has been accepted that although EMEA, all the witnesses who really had anything to say to it, I think the last one was Mr. Matabuch, that although EMEA prescribes 30 days, it's seldom achievable. But that's one thing I think everyone accepts. But how do you strive to make sure that matters of that kind, even if you don't meet the 30 days, are dealt with speedily? And maybe let's make up, or rather make a list of live examples rather than talking about it in abstract. The CR17 Busasa matter, that Mr. Mataboge testified about? How long did it take you from the time of the complaint to the issuance of the report?
I think the CR17 Busasa matter took us up to, it was around 8 months
Yes.
to finalize, to issue the report on that matter.
Okay.
And there is the matter of the so-called SARS investigation, so-called rogue unit investigation.
Mm.
When the complaint was lodged, there were around 12 issues which we were supposed to investigate. One of those issues was the complaint against Minister Kodan of the executive, that he lied or allegedly lied to the fact that he never met or he met the Guptas, something like that. So then we had to split that investigation into two so that we deal with some of the issues and with the Executive Members Ethics Act, and then the remaining 6 matters, we then were meant to deal with them and investigate them under the Public Protector Act. But then that Executive Members Ethics Act investigation, I think it took us around 7 months, if I'm not mistaken, from
Good.
start to finish. Yeah.
Thank you. Okay. Now with those examples, and so that there's no confusion, when you're saying you took then the average of 7 months or 8 months to deal with those matters of that caliber, you're not talking about what we are experiencing now. You're talking about from the complaint actually to the report, not to the Section 7(9), which was leaked last week, I think, in the Parliament. So the Section 7(9) would have been issued somewhere a few months after the initiation of the report, or can you remember?
Yeah, the Section 7(9), because I think there's a recording which we've shared with the members of the, in fact, we've uploaded where I was interviewing the president. Where I was interviewing the president. I think we've uploaded that recording. I think it was around May, if I'm not mistaken, or June. We'll have to confirm the date.
Yes.
But then it was, I think, within 2-3 months after we've received the 3 or 4 months after we've received the complaint. So normally we would do that. And during the investigation, acknowledging that the investigators have other kinds of investigation which they are dealing with. And again, the level of the person who's investigating the matter, especially the Busasa matter, was investigated by Mr. Mataboge, who was here, one of the witnesses, and who indicated that I said to avoid leaks, to avoid compromising the integrity of the investigation, and as well protecting the president, it's better if it's few people who are investigating the matter so that we don't see information out there. So, and the very same person, you'd find that they are having investigators reporting under them. They should be making sure that they deal with their performance. They also have to conduct their investigation. So that's what transpired.
Yes, thank you. Well, just again, so that we don't have to traverse that road when we deal with CX and Fred and all that.
Just a pause before you proceed. Honorable Mwala.
No, thanks, Chair. I want us to follow the testimony properly. Is Advocate Mbofu putting it on record that the Phala report has not been issued by PPSA?
Yes.
It just got leaked. I want us to follow properly.
Yes.
Thank you.
Thank you, Honorable Mwala. Switch on your camera, Advocate Mkhwebane. Over to you, Advocate Mbofu.
Yes, Chair, yes, then I'll help you to take half a minute, yes. No, again, for the thank you, Honorable Mwala. No, what happened is that you know about Section 7(9) by now. Yeah, the Phala investigation, as the witness said, started in June of 2022. let's say 9 months later, which was last week on Friday, the Section 7(9) letters were leaked in the media. There's no report yet. And that is unfortunate. We'll, when we talk about the problems within PPSA, we'll talk about the leakage. Even the CX report was leaked and deliberately, I think. Yeah. So we're still far from a report. That means the president and General Rode and all those people who are implicated have now been given their chance for Audi, which should never have been leaked to the public, but unfortunately it has. Yeah. All right. Thank you. Now that, well, okay, I was just saying, in the spirit of killing too many birds with one stone, now that Honorable Ngola has raised the issue, can you explain that? Because to be honest, it's not as simple as it looks, because particularly in the time of Professor Matanzela, the Section 7(9) letters were called provisional reports. So that even causes more confusion, yeah. But just please educate us, Public Protector, as to the stage of what happened last Friday. You must have seen it in the media, of the leakage of the Section 7(9). What does that mean in terms of your processes? You've told us about your processes so that we don't have to revisit that. Complaint, you've told us. Then you write 31 questions, what have you, and so on and so on. What is the Section 7(9) stage of what was leaked on Friday?
If we investigate the matter, there are various stages where we involve or we engage the complainant. Hence, I indicated that in any complaint, we would inform the person in fact, if you receive the complaint, we will have to inform you as the implicated party that we've received a complaint. Can you then assist us with the investigation? Definitely, we wouldn't just conduct an investigation in secret without informing you as the implicated party, hence the 31 questions. When we receive your response, because again, when I joined PPSA, there were no rules. Your rules are like your regulations to the Public Protector Act. So we had to have the rules so that we assist even the state institutions, the executive, to understand when a complaint is lodged, how long must it take for us to investigate the matter? And as the implicated department, how long should you take to respond to us? So normally in terms of the rules, when we issue you with that letter, we give you up to 20 to 30 days to give us your side of the story. You respond to that particular matter, and we request further documentation so that we can also be brought in our investigation, that we deal with all issues, or so that we are not only restricted. I think you mentioned the Malian Guardian case earlier, to only what complaint was lodged on. And by doing that, we also assisting to deal with the root causes of any particular malfeasance in the system. So we will then investigate, and that helps us to have the leads, because we will then see, okay, you've responded as follows, this is the complaint. Then we need to approach possibly another department, SABC, we need to approach SARS, or we need to approach the Reserve Bank, or then we have to subpoena bank statements. We have to approach Home Affairs and say, if the person has alleged that I never traveled, what is the movement control system saying about that particular issue? Then after doing that, we then check the allegations against the evidence before us, against what the law requires a person. That's where we compile that Section 7(9) notice. And I think we're still going to deal with it in details, because in the past we used to with the CX matter, it had the remedies already. Thereafter, after the challenges of the CX matter, then legal services gave an legal opinion that, but if you strictly read what section 7, subsection 9 says, it says you serve that notice to the implicated parties, because we came to you, we indicated that there is this complaint, you responded, and we are saying to you, here is the complaint, here's your response, here's the evidence, what is the law saying to that? Application of the law to those facts, it shows us that you have violated this legislation. So that's what section 7(9) says.
Okay.
And that is only served to the implicated parties. And we normally say you shouldn't share it. And because there were instances where a report will be leaked, or as a provisional report. Well, when I arrived, my predecessors, some of the reports or provisional reports were leaked. And then people will think that, or as well, they used to serve that provisional report to even a complainant. I think hence Advocate Hoffman complained or also thought I violated the Public Protector Act by not being or by not sharing the CX section 7(9) with him. So normally we don't serve it to the complainant, but what is required of us, especially in terms of our service standard, is that every 20 days or every month, we should be updating the complainant about the investigation. So that's what section 7(9) notice is. It's not for the benefit of everyone. And remember, that can change the contents of the report, because you might respond to the section 7(9) and then we can say, we would be saying to you, you are implicated, the matter is substantiated. But when we receive your response, sometimes we'll say, no, the complaint is no longer substantiated. Or when we receive your response, we'll say, definitely there is evidence, and then the matter is substantiated, there is a finding.
Good, thank you very much. And Chair, again, without deviating, but I'm just taking advantage of Honorable Mwala's question so that we put this issue to bed of the stages. It might sound like Honorable Mwala's question is simple. It's actually very complicated, because one of my juniors was also asking me after the leakage on Friday to say, now, there's headlines that say the president has been exonerated and what have you. So if he's been exonerated, then why is he served with a section 7(9)? And the answer, just for the members, when we deal with the Busasa matter, we'll deal with that, is that it's in any event, and I just want you to confirm that, in terms of EMEA, when there's a complaint, which is an EMEA complaint, just by coincidence, the law requires you to serve that report to the president if it's a member of the cabinet that is being complained about. So it's a two-way thing, even though the accused, quote unquote, is the president. But because he's a member of the cabinet, the report has to be served on him. And that is, I think, the context. And you'll find that, I won't even put it up, Chair. When we deal with the Busasa matter, we'll deal with it, but it's in paragraph 12 of the Busasa judgment, where the majority judgment of Chapter J said, the section does not explicitly prescribe the procedure to be followed during an investigation. However, it mandates the public protector to follow processes outlined in the Public Protector Act. The exercise investigative powers afforded to her by that section, by that act. The section contemplates a swift investigation which must ordinarily be concluded and a report be submitted to the president if the complaint was against a member of cabinet or deputy minister, or to the premier if the complaint was against an MEC. So is that how you understand the law?
Yes.
The EMEA? Okay, thank you very much. All right, thank you. Now that we've put that aside and we know what it was that was leaked last week, I just wanted to you've told us that in your time, matters of this caliber, you took in Busasa 8 months for the full thing up to the report. We're still far from that in Palapal. And you took 7 months or so in respect of rogue unit. That's even better. And I just wanted to also deal with another issue which was raised about, I think even your most ardent critics sitting where you are sitting now have acknowledged how you have improved the speed with which matters are dealt with. So it looks like you took Premier Masaole's advice to heart. Now, in relation to that, just to wrap up some of the matters that we're going to deal with, we know that there's a matter of CX, one of the key matters here. How long did it take you to deal with that matter? And for the sake of perspective, the complaint was in 2010. And in 2016, 6 years later, the time of the retirement of your predecessor, there was nothing, there was not, according to her, there was not even a draft report. How long did it take you to deal with that matter?
I joined the institution 15 October 2016. We issued the report, I think, in June.
Yes.
It took us 6 months to finalize in fact, to issue the report. Not only the issue of Section 79, no, but just to finalize that investigation.
Okay.
And I think what is key and critical, Chairperson, is that this institution is meant to be exemplary. I think that's what I also indicated during my interview, that we need to lead by example as public protector. We investigate undue delay. Therefore, undue delay shouldn't be what we are accused of. I think, and that's what was driving me to say we cannot have work which is just piling up and not be finalized. And while the investigation was, all the information was already collated, whatever we found there, the interviews, the recordings of former President Mbeki, former governor, all the people who were interviewed, the records which we found there, then we decided possibly we can move on this, but also we couldn't move without me satisfying myself that, okay, this investigation, what is the root cause, or why did we in the first place accept this complaint and investigate it? I think my predecessor indicated that there was that agreement which was signed between the secret services here and MI6, not MI6, the CX company which was investigating. So, and that was because when you listen to the recording of President Mbeki, it was very clear that he didn't want to deal with the matter himself. Therefore, it should be dealt with by South African intelligence versus the other counterpart, because it was an issue of in that sphere of investigation. Yeah.
Thank you. Yes. All right. No, I think one of the people who assisted you, who testified here, I can't remember the name now.
Levuani, no? No.
Mr. Chwalule. Yes, yes, he confirmed that. Yeah, you came in October, you familiarized yourself, and by November, December, you had done that, and then you gave them the matching orders, and 6 months later, the report was out. Thank you. All right. So, again, the Freya matter is another one that is going to feature here when in the next days or so. Again, that one, the complaint was in, I think, 2013. So there was 2013, 2014, 2015, 2016, 4 years or so later, your predecessor had not produced the report. And how long did it take you to deal with that matter up to the report?
I think 2016, we issued the report in 20, is it 20? I think it took us still 8 months, if I'm not mistaken, because already a lot of work has already been done. And I think that's one of the key issues which I was excited that the public could hear Advocate Madonsela or Professor Madonsela saying he never issued or he never even signed the provisional report or the Section 79 because it was still drafts and she was still guiding the officials what they need to do, which matter is the very same matter which I was accused of having changed her report. So
Yes. Okay.
that's one of those. So I think I took that time to investigate or to finalize that matter. And if you'd see sometime around 2015, there was a stage where there was a media statement by my predecessor saying the investigation is complete and then they will be issuing the report. But there was never a time where the draft or the Section 79 was, or the provisional report issued in terms of Section 79 was signed and issued. So that was the process which we had to deal with.
Yes. Yes. Again, somebody testified about this, but just for the record, Chair, that report was issued, that's now so-called Friday 1 on the, in 2018, about 14 months or so after the,
Okay.
but we'll get the time. But anyway, the point is that you had two reports. One had been there for 6 years. The other one had been there for about 4 years. And you took a relatively shorter time to deal with those. We will revisit that issue when we deal with CX and Friday. All right. Back to where we were, Chairperson. So now the Constitutional Court, rather, yes, here's your matter, and it is we're waiting for that judgment. Now, in the meantime, you have said in your statement that the reason why you wanted us to start with the CR17 stroke Palapala stroke Busasa matters, you say in your statement, because you say that is what this matter is really about. If you go to paragraph 6 of your statement, again, just for the sake of progress, Chair, if I can read out the extract from the Nkandla case that the witness referred to earlier in passing, but just to place it on record, please go to paragraph 6. Okay, I'll just read out the part that is from a court case. The rest is your statement, so you'll put it in your own words. Go further down. Yes, this, and you'll just work with me as when I get to the next. You'll move. Yes, this is one of the defining statements on the public protector, Chair, which really puts, if anyone, as the public protector says, those who have ears will hear and those who have eyes will see. This is, according to the statement, why we are here. The Chief Justice said, her investigative powers, her meaning the public protector, are not supposed to bow down to anybody, not even at the door of the highest chambers of raw state power. That would be otherwise known as Mahlambandlovu. The predicament, though, is that mere allegations and investigation of improper or corrupt conduct against all, especially powerful public office bearers, are generally bound to attract a very unfriendly response. An unfavorable finding of unethical or corrupt conduct coupled with remedial action will probably be strongly resisted in an attempt to repair or soften the inescapable reputational damage. It is unlikely that unpleasant findings and a biting remedial action would be readily welcomed by those investigated. So according to Justice Mkhwebane, this is just the nature of your job. Take it or leave it. But it is when you do your job, it's unlikely, or rather it's likely to attract a very unfriendly response. Now, you say that in the context of paragraph 6, about what you say is what this matter is about or not about. And maybe, Chair, just to, if you beg your intelligence, I'd like the public protector then to link that statement to her own words by reading out paragraph 6, and then I'll ask you a couple of questions.
I think this shows that
No, sorry, I'm asking you to read it out, paragraph 6, then I'll ask you the questions.
6 or 7?
6.
Okay. Before dealing with my credentials and some of the overarching information, it is crucial to put my evidence into its true and proper perspective by calling out this process for what it is and what it is not, in my honest opinion. For the record, I do not for 1 second believe that this process represents a genuine impeachment process. It is merely a politically motivated witch hunt, a reminiscence of the inter alia, the words of Chief Justice Mkhwebane speaking for the unanimous Constitutional Court. When he said about the pipe protector, I think the SC has already read this, and I think I said to SC that Chairperson, the prophecy of CJ Mkhwebane is coming to fruition, because exactly what he said, it's what I am currently going through.
Thank you. And then maybe so that we can round off that point, you could go to paragraph 7 and 8.
Yeah, whilst going to paragraph 7 and 8, I should also indicate that for paragraph 6, that section 181 subsection 3 of the Constitution is very clear that Parliament and any organ of state and anyone has a duty to assist the public protector, the Auditor General, Gender Commission, and all other Chapter 9 institutions. So this shows that, if you then investigate the untouchables, which I think you, in the opening, you indicated what this is all about, besides the political motive, but also the capital and, those who have deep pockets would then use this particular process. So this process, as I said earlier, is a special project of the Democratic Alliance, which is aimed at scoring political points. As the first party to have ever caused a head of a Chapter 9 institution to face impeachment proceedings, this process has nothing to do with accountability. I think I was told several times here, no, public protector accountable to Parliament. I've done that without fail. And, when appearing in, before the Portfolio Committee on Justice, If you go through the annual reports, which we'll go through, are used to indicate the challenges. And it's for that portfolio committee as well to see how can they put section 1813 to life, because they were the ones who were supposed to make sure that whatever I'm doing, or even counsel and guide me if there's something which I was not doing correctly. So it has nothing to do with the constitution and the rule of law, because at the end of the day, I would say 90% of the complaints, EMIA, Executive Members Ethics Act complaints, which were lodged, were from the members of the DA against the members of the ruling party. And the very same Busasa was from Mr. Mkhwebane, who was the head of DA. So it has nothing to do with the Constitution of the Republic and the rule of law. So this process is far removed from the Constitution, as the South is to the North. It is a politically motivated witch hunt and masquerading as a bona fide inquiry under the auspices of Section 194 of the committee. So it is a racially motivated, because I would say that born out of fear of change, which might actually benefit the poorest and the most marginalized members of the public, who are in the main blacks, and at the expense of those who benefit the most from the economic status. That I will say it boldly, and I should have even given examples in the past where I would say you'd find your CASAC, your Freedom Under Law, and all these NGOs who should be helping and working with the public protector to deal with the marginalized, the triple challenges of this country. But they would be the ones who are taking me to court. They will be the ones who in cahoots with the DA to just deal with me. But when it comes to these high profile matters, which I'm not going out there to look for them, because I do have an own initiative mandate as the public protector. But most of the time I would do that, but I wouldn't do an own initiative investigation as far as matters of concerns are like this. So unfortunately, I find myself in this particular position, and the issue of the DA trying to get rid of me and to punish me for doing my work as prescribed in the Constitution, to do my work without fear or favor. Unfortunately, the current ruling party also aided or assisted them in this particular process, because if you would see the kind of work which we did with my or the staff of the public protector, you would find in my affidavit I would say we, because this is the work which we've been doing together. And what CJ Mkhwebane said in the opening, that one will be dealing with the raw state power. It's exactly what happened, because the CR17 Busisiwe matter, the investigation was done honestly. It was launched by the very same DA, and we investigated it openly. The issue of Minister Gordhan, again, it was launched by EFF, because also the using Executive Members Ethics Act, we investigated it with the team. And I think that's what I've shown, that I work with the team. They are investigators who conduct day-to-day investigations. So these issues which I've mentioned here in my affidavit, I mean, the issue of Mr. Pillay, who the complaint came through a whistleblower about this matter, I need to indicate. And that whistleblower by then was working in the Deputy President's office, the current president. And unfortunately, it's one of the journalists, the late, what's her name, who then exposed that particular person and causing serious damage to that whistleblower. And because he was employed and asking, but how can something like this happen? I'm also a public servant. Can I really resign and the following day, within an hour, be appointed? But then I think my responsibility is to make sure that I assist this country per the policies of this country, per the law, per the rule of law, to make sure that we have clean governance. But unfortunately then that the DA made sure that they only focus on a certain caliber of people you need to be investigating and forget about the poor and the marginalized.
Thank you. Okay, maybe then for the sake of completion, with the leave of the chair, if you can then read the rest, you just stopped halfway with paragraph 8. You can just read paragraph 8 into the record.
Then, yes, assisted by the ANC, which is driven also by separate motives of retaliation and revenge for having exposed corruption and other wrongdoing on the part of its most powerful leaders. I would say that this investigation against the president, which we'll deal with in details, and the evidence which I honestly, or we honestly received and dealt with and tested it against the existing laws and not any ulterior motive. The issue of the pala, because that led to my suspension. Especially we've dealt with the issue that I wrote the letter, asked the questions, and I mean, that led to the issue of my suspension, not even waiting for the court to issue their judgment, the likes of Minister Pravin Gordhan, in respect of the so-called rogue unit scandal and the fake retirement of Mr. Pillay, because that is clear and there is evidence which we are going to deal with in my evidence, so that I can go and take through members of the public through the report, because the report, what evidence we relied on, and what legislative framework which guided my work. It was not at all based on the fact that I am just targeting certain individuals. And I think these investigations, especially against Minister Gordhan, it was because he was the accounting officer at SARS, and what are his responsibilities in terms of what the Constitution is saying and what the relevant prescripts are saying. So as the Chief Justice has said, Mkhwebane, that such investigations are generally bound to attract a very unfriendly response, which I've been receiving since I joined the institution besides DA. And I'm saying the ANC because I've got evidence of various members of the executive making very, very disturbing remarks against me. I mean, even Minister Gordhan writing those in his affidavit, you know, and the court had to strike off those comments. So that's what I'm facing, or that's what I would say to the members of the public, and for them to understand where this process started and what is happening. And when we deal with each matter, then I will have to take the public and let them be the judge and indicate, because one is also being accused of being factional and all those. And I don't know how many times one has been saying, I'm operating in the political space because of this Executive Members Ethics Act, you know, SC and Chairperson. It's just that we were dealing with this statement in a rush manner. There is one presentation I made to Cabinet, first time the Public Protector appearing before Cabinet. And it was a question, why is she doing this? But again, being honest and trying to make this state of ours to work. 29 March 2017, the current president was the deputy president, where I was presenting Executive Members Ethics Act and saying to them, my predecessor issued a report, the Nkandla, and recommended that you amend EMIA. And by then, I was also saying, she only dealt with when you investigate the president, you don't indicate who to inform, especially Uguti, you are still investigating. Because when you investigate an MEC or a minister, you inform the premier or you inform the president. But then with the president, there's no way. So the only way is to inform the speaker. You know what I did? I still have the presentation which we can share. I then said, I'm not impressed. I'm not happy. I don't even want to investigate under this EMIA. again promoting the issue, Uguti, why don't you have a situation where in the EMIA, we have it like in the Public Protector Act, where we say public servants exhaust your internal remedies first, because I was saying you should exhaust this process in Parliament first. Unless then when you fail to exhaust it, then it's escalated to the Public Protector. That's what I was trying to do. But unfortunately, as if I was also like Chief Justice Mkhwebane, foreseeing where one is going to end up, especially on the persecution and the comments made by some of the members of the ruling party.
Right. Now, you've touched on all the accusations about you being involved in the factional politics of the ruling party in particular. And indeed, one of the charges of Ms. Mazzoni, Honorable Mazzoni, I think it's 11.3 and 11.4. And we know it's been trumpeted here also many times, as that, no, you're, I'm trying to paraphrase, you target certain people of certain factions of the ruling party. For example, Mr. Cyril Ramaphosa, President Ramaphosa, Mr. Gordhan, well, all South Africans, we know how the factions work. And then you exonerate, even when there's like overwhelming evidence, like even pictures, and I suppose, of things being taken away, certain other people of other factions. And the examples that have been used, the Mr. Makashule and Mr. Zwane, Msebenzi Zwane. In other words, if I'm in this faction and my matter goes to the public protector, definitely I'm going to get the chop. But if I'm in the other faction and the matter goes to the public protector, irrespective of the evidence, I'm going to get condemned. That's Ms. Mazzoni, or let's call it the Mazzoni theory. Now, you know, these things are easy to just put on paper, as you call it, a narrative. Let's just examine the real facts. Some of the people that you have found against, can you just tell us some of the people that you have, without necessarily allocating them to a faction? I think South Africans are wide awake as to what happens in those dynamics. Who are some of the key people that you have found against?
There were several Executive Members Ethics Act investigations, because those are the cause of why I'm sitting here, being accused of those by some who don't want, or who just take whatever they are being told by the media without, you know, honestly understanding what's happening. In Limpopo, there was a report we issued against Ms. Mkhwebane. It was relating to EMIA. There was a report which we issued against the then Premier of Western Cape, Ms. Zille. There was a report we issued against the Deputy Speaker of Limpopo. The report we issued against.
So that we hear all of them properly. So just get closer to the mic.
Okay, against the Deputy Speaker of Limpopo, and then against the former Minister of Sports and Recreation, Mr. Mbalula, former Minister Malusi Gigaba, former Minister of
Kokta.
Of Kokta, yes, Mr. Van Rooyen. There was a report which we issued against the MEC of Health, Simelane Zulu, Western Cape, former MEC, MEC Matikizela, a former Minister of Agriculture, Forestry and Fisheries, Ms. Tina Jumat. I think some of them, some matters were not substantiated, but then I'm just indicating who are the many people we investigated. There were some of the complaints lodged by against the MEC of Western Cape, Riddell. There's also complaints lodged against the president, President Ramaphosa, the MEC of Gauteng, Mr. Mamabolo. So those are the investigations which one has conducted. And I must indicate that some of them were substantiated, some of them were not substantiated, and across all aspects of our investigation. So there is nothing, because these complaints, as I said, were lodged by the very same, you cannot, as a member of the public, lodge a complaint under the Executive Members Ethics Act.
Yes.
So are lodged by the very same members of parliament against each other, or members of the executive against each other, and which helps, because what President Nelson Mandela said in that university in Taiwan, that, you know, we are not above the law. We would want somebody to help us to act, you know, ethically, and to also have somebody who will oversee our behavior and represent or protect the public, so that we don't abuse our power. So these are the investigations which we have done, and some of them were not substantiated. They were closed. Several reports which were issued, which we said the matters are not substantiated.
Okay, thank you. Okay, I think to make this point, I take that point, Public Protector, but maybe to assist really with the point about your alleged factional, let's call it favoritism or allegiance. Please, I take the point that you're saying these are the matters investigated, but I'm asking you specifically about persons that you made findings against. All right, in the context of what we know as factional politics in South Africa. Maybe I should just ask you like this. In relation to, I'll just pick out some of the matters that you mentioned. In relation to Minister Des van Rooyen that you mentioned, did you make a finding in his favor or against him?
Minister Des van Rooyen, it was against him.
Yes. And then in relation to Minister Lynn Brown, did you make a finding in her favor or against her?
It was against her.
Okay.
And that Minister Lynn Brown what was worse was that utilizing the very same code which is alleged to I have changed, because we said it was not deliberate on her part, because she was misled by the department, the DG of the department. And we said in future she should be very careful, make sure that when she responds to Parliament, she's also happy that it's credible information. But unfortunately, those two ministers, the president wrote a letter back, immediately acted on those two reports, and informed me that I've implemented your remedial action. I've taken action against these two ministers.
Yes, and those actions against those ministers were taken against what was now trumpeted by Ms. Mazoni as having used the wrong code.
Definitely having used, because that code, I mean, has been used since even my predecessor. There's several cases which will take the committee through, Boshikeka, Bodainapule, Nomvula Mukonyane, the same code which I'm said to have changed.
Yes, okay. Just against Minister Malusi Gigaba, did you find for him or against him?
It was against him. That one was one of the matters which if I'm not mistaken, this matter, the investigator who was specializing in EMIA matters, I think it was done as well, one of the quickest one which was done because it was only focusing on what the court has said and what Executive Members Ethics Act is saying about what is expected from the members of the executive. So it didn't take a long time to investigate that particular matter, but I must indicate that it was against him.
Yes, thank you. And then the one that's more difficult to pin down because factionally speaking, because maybe on all the factions. Okay, against Minister Mbalula, did you find against him or for him?
Minister Mbalula, it was against him. The issue of the evidence which was there before us, which was, you know, as well brought to his attention, and it was against him.
Yeah.
And as one of the ministers who also insulted me about our investigation.
Yes. All right. No, so, okay, fine. Then, as I say, it's easy to just allocate people to factions and choose those that you want to choose. But the insults, you talk about insults. Again, I suppose that comes with the territory. But how did it make you feel? Or rather, let me start it like this. I said in the opening address, and this is something I've discussed with you many times, as I say, also because it touches on some of my personal experience. The question that you get asked all the time, what got into your head to take a job like this when you know what's coming? Now, I'm asking that question in relation to you are a South African. You were here around the Kandla scandal and all that. You saw how your predecessor was vilified, insulted, and really, belittled. And we won't mention how she was belittled because then it's assumed by those who have the minds of a peanut that you are therefore insulting the person yourself. Yeah. But having seen those objectionable insults against your your predecessor, you still put your name forward for this job. So how did, well, firstly, because you are human, I'm sure you knew you were getting into troubled waters, but what drove you to still make yourself available and take up the challenge, irrespective of knowing that you are going to be vilified, and look at where you are sitting right now?
You know, I never applied for the position. I was approached, in terms when they advertised the position, they called on the public to motivate and approach us. One of the staff members I worked with, the Home Affairs, approached me. I agreed, submitted my CV. And I remember before the interviews, my late mother was saying to me, I've seen how they treated Thuli Madonsela. As I said during the interview that my mother was used to follow the current affairs, listening to Ikwekwezi. And so she was saying, I don't think you would want to be treated like that. So, and, when she said that, in fact, a lot of my peers as well at home were saying, you don't want to be subjected to that. But then I said, I would want to serve the public because in my space, I used to work in the very human rights related environment, humanitarian issues. So I said, I would want to help the public. I would want to make sure that, you know, I'm the voice to those voiceless, and being a carrier and a person who can help in that space, I would want to help. So I must indicate that, you know, when we called my predecessor to come here to also be the witness, and I think you remember, I'm the one who said, please, can we also include her? Because I was expecting her to deal with, you know, what she was going through. I think there's a question where you asked, Uguchi, I mean, when some of the members, some of them are part of this committee, because I mean, history has no blank pages. When you go back and see the videos on how some of the members of the Justice Committee used to treat her, deal with her, insult her. So I thought she would understand the position I'm in today, and also to help South Africans, or even the members of the committee, that you don't have to treat a person like that. But you know what, SC, what gives me peace and what gives me joy all the time, or chairperson, is that there are a lot of members of the public with the team of Public Protector South Africa. And I mean, some of those who were scared to come, or some of them were told that you must just bring what is negative about this woman. But they would tell you that I always said, how do you sleep at night when you have a person who's coming here desperate because they've been failed by the system? Whatever happens, whatever negative comments, but let's make sure that we make a change in the summer. You know, it gives you a fulfillment to find people who are sleeping, makeshift tents, families dying, old people. But when a roof over their head is constructed, and they would say, you know what, at least now we are protected. That's what is keeping me going. But I think the main thing is that I'm not about your Busasa CX rogue and whatever. I'm in this position because I would want to free and to make sure that the very same thing which is being said, which the Constitution is there for the poor, the marginalized, it's indeed a reality. So at least we've tried with the staff to make few to enjoy it. But I must indicate that, or even, I think you can exonerate yourself, some of you, of the members who were serving during Madonsela's time and who are still here. Ask yourself, is it the way you should be treating this institution, which is there and which our forefathers said it will help in liberating the poor and the marginalized? Yeah.
Thank you. Advocate Mkhwebane, Advocate Mpofu will pause there. We'll take a 45 minutes lunch. We'll be back at 2.
Thank you, Chair. So it's not just the poor and marginalized, it's the hungry as well. Thanks.
Recording stopped.
welcome back. I hope you sorted out PP. You settled. Thank you. Welcome back, colleagues. We resume our work for this afternoon. Over to you, Advocate Mpofu.
Oh, thank you, Chair. Sarah, I didn't hear. Right. Thank you very much, Chairperson. Okay, Public Protector, we broke at a point where you were talking about the humiliation, the insults, that your predecessor had suffered, and where even in your late mother had warned that why do you take such a job when you can see what has happened to your predecessor? And I know that even your sisters, Jeanette, they always told us that they try to discourage you from doing this because it was one way to trouble. But you've explained why you insisted on doing it and why it gave you such satisfaction to deal with members of the public. Now, I just want to round off that point by relating to something you touched on before lunch, which, you know, you said it in passing, but most people don't even know it, that you should explain why it is that when the date was set for this process, around about June or May, and we asked you to give us lists of witnesses. One of the first names that you suggested was that of Thuli Madonsela, in line with what you have indicated. Why was it so important to you? And Advocate Bauer confirmed last week that indeed she was on our very first list. Well, it was on their list and then she was on our list. In fact, probably one of the few names that appeared on both lists. Why did you feel that you needed her evidence to the extent of asking the committee to subpoena her, which was kindly acceded to, subject to the hijacking exercise that happened?
Thank you, Chairperson. I think Advocate Mpofu, as I said, yes, I'm the one who requested, because for me, I felt she could relate to what I am going through currently. And as I'm saying to you, that the warnings came from my late mother, and she knew how she was treated. So, and the hostility towards her. And I mean, being an African woman, also going through that, and some of the people treating her like that, I thought she would come here as well. When asked, I think as well, Honorable Holomisa asked her, she would then also put issues into perspective and speak with that voice and with after going through that hostility. And unfortunately, you know, I kind of was discouraged in a way, because I thought she would, you know, maybe speak sense to some of the members of the committee, and you know, inform them that it's not easy to do this kind of work, and you are second guessed, you are insulted, and it's as if you are going around and wanting to find people guilty. So I felt, well, sorry for that particular process. And I think, and it's true what you're saying, members of the family, my friends, Well, my younger brother always would say, I told you long time ago, you should not be doing this work because some of the work which you've done, especially the untouchables, especially capital, because he used to work in the public service, but interact with various racial groups. And he would say, you know, you don't find against certain individuals. So I felt shame and I felt we should be helping each other, you know, as sisters keeper. But I would say my successors in title, I wouldn't want them to go through the same thing. I think we need to stop this. And hence I'm saying to members of the committee, some of them, those who have ears, let's not continue doing this because sometimes you are being used by the powers that be so that you don't, you know, liberate people from this cycle of oppression, because some people are benefiting out of the fights amongst us as Black people.
Yes. Thank you. Now, I think you've already answered my next question, how you were discouraged or disappointed. And but how did it make you feel when you were now, instead of, I know you expected her as someone who had gone through what you had gone through to maybe educate us, but how did you feel when it was actually suggested that you only called her, in other words, you were referring to Honorable Olumisa's question about the insults that were held against her, that actually you, through your lawyers, I suppose, were the one who was in making those insults. How did that make you feel?
I felt sad, and it was a shame actually for some people who are thinking like that, because I thought, you know, people will understand and as well just try to show that whatever is happening now, we need to bring a stop, or we need to stop this persecution. But then I think when that matter was raised, it was to make sure that it's dealt with once and for all, and so that people are not concentrating on such petty issues, but they understand that she was doing her work the best she knows how, and the vilification, it was not justified against her, and the body shaming and all those. But I thought, you know, she would also come to my rescue. But I think it was as if there was that issue of, it's as if you wanted to embarrass her, or I think people took it as if we are fighting or we are in a fight, or, you know, so sometimes it was more of not being cooperative, but we were trying to show that, you know, whatever is happening, was happening to her, it's still happening even to this day. I mean, and besides the issue of body shaming and everything, also the issue of the judgments and what happened with her and how the members of parliament, some are treating her, were treating her, the same thing is happening. Can we stop this cycle? Yeah.
All right. Well, then I don't think you should bother yourself if you want my advice about what I said, the minds of the size of a peanut. But anyway, so if you can go to paragraph 14, no, sorry, Chair. You at paragraph 10 quickly, which is page 6, Tsepo, page 502. Yes, I think you covered 8 and 9, and the here you talk about an unholy alliance. Just to round off the issue of how you see this process, can you go to take us to paragraph 10? Sorry, is the computer taking slow? I can read that one on the screen without my glasses. So I don't know which one you prefer, the screen or the computer, your computer.
No, I'm reading my computer here.
Okay, can
Yes.
you please then take us?
Yes,
to
it
paragraph
is.
10?
All right. It is these factors which have led to the formation of the unholy alliance between the DA and the ANC to advance their common objective of removing me from office by hook or crook. And if the courts are to be believed, mostly by crook, because, can I elaborate?
Yes, please.
I mentioned this because I indicated earlier that when the charges are read or when people are meant to take an oath, it's like the removal of the public protector. It's as if it's concluded that I should be removed. And the worst thing is that, as the public protector Sokoni said, that when she was testifying, that it's as if, or if we take the judgments as they are, and I think you've tried to deal with those.
Yeah.
If a judge, and even my predecessor, you asked the question and you read that NEF judgment and the SABC judgment, if you take it as is and you charge a person, like Honorable Mazoni indicated that I should be charged because I've lost the following cases, then, and those judgments which we've shown and we're still going to show that they are based on wrong facts. I mean, it's very clear that I should be removed. And I think I mentioned these parties specifically because the speaker should have made sure that she's not possibly tricked to thinking that that is the way to go about, because it shouldn't have happened in the first place. And I think I'm also mentioning it here because, you know, during the weekend, I went to some wedding where somebody comes to me and say, hey, you are in parliament, you are an ANC person, and what is happening about this? We don't have electricity and stuff. I said, no, I'm not an ANC person. The very same ANC is also now persecuting me. Why do you say I'm an ANC person? So that's why I wrote it like this, because this shouldn't have been allowed, that I come and sit here. State payers' money is being used to just deal with me the way I'm being dealt with.
Thank you. And thank you. Earlier in the morning, you went through about talking about taxpayers' money, how many attempts you have made, even to this committee, of saying, please, let's not waste money. We're in court. Let's hang 10 on the process and maybe wait for the court process. But there was this eagerness to continue wasting the money. And we heard from the chairperson last week that the same people that were refusing your request to save the money by waiting for the court processes are now saying that you must proceed effectively without legal representation. How does that make you feel?
You know, Advocate Mpofu, a chairperson, it makes me feel very sad because the very same, one of the charges is charged, 3-4, where I'm charged or I'm being told, or the Honorable Mazon, who's supposed to come here and explain between legal cost and legal fees. What does she mean? Even the very same cases which I'm said to have lost, we were defending the very same public because we investigated the matters And those who have deep pockets take us to court. And I thought when we defend the matters, we are helping the court to understand that, can you make sure that the very same poor and marginalized get justice? Now, on all the matters which we spoke about in the morning, issue of retrospectivity of the rules, issue of legal representation, which at the end of the day, and the very same thing of suspension, not waiting for the court process, but also it's as if it's retaliatory. That's what has been very clear. Now we're in court on Monday saying there are these issues of conflicts. Honorable Melham, Honorable Janji, you know, it's not what you feel. Yes, you can say, no, I'm fair PP, but how do I feel with you being part of the process? And the letter we wrote in January, or is it January, where we were saying to the speaker, or when Honorable Mutsaha by then saying, talking about issues of incompetence
Sorry,
and stuff.
that's PM3, the letter of January
Yes.
2020. Yes.
And the rules of parliament are very clear. Rule what 88. Uguti, you cannot comment about the competence of an institution. So it's that. And now we appeared at court. We're hoping Guti, the justices have had, and also it's for history, which will have to be made as well. Can you really, in the midst of all this Supreme Court of Appeal judgments, international judgments, go ahead and allow a situation like this? Because at the end of the day, they'll come back and say, you know, if they say, no, but this matter, you cannot have these people must be recused, then you're risking the whole 9 months. How much have you paid my legal team? How much have you paid the evidence leaders? How much have we spent, me coming here, the office paying, and the very same office which has written to the speaker now and the chairperson that they won't be funding come end of March. And there's a constitutional court judgment which says you need to be represented. So how are we going to proceed, chairperson? Because then it means your process will be stifled. The very same office which they were not a party to the Western Cape High Court. They sent directors of firm of attorneys. They sent SC to just be on a watching brief, where they asked how much was that. So I think let's just look on through all these matters. I mean, Honorable Hendricks once said possibly 1 million is being spent, which I think that was asked. We would want to know how much is spent. Is it worth it? Now I'm remaining with how many months in this position, and we're still pushing this particular matter. So I think, yeah. And all in the name of what? And all in the name of what? Me doing my work.
Yeah, well, as they say in the streets, it is what it is. Now you take us to now, okay, let me maybe round off that point. Yeah. If you had been listened to, for example, when you said in October that when you said that let's stop this and wait for the recusal review application. I think that was in October, on the 27th of October last year. If you had been listened to, then, well, we don't know how much money would have been saved, but we know that a lot of money would have been saved. But maybe to explain to the members of the public, the case that was argued on Monday in court about the recusal of Honorable Mileham and the chairperson. If that succeeds, then what will happen?
As I said that, I mean, it will have to start de novo, afresh, and how much has been spent in this particular matter. And if we were given an opportunity and, you know, correct that, have other members or then reach a settlement, I think we wouldn't be in this situation. And I think we would have saved a lot of money. But again, still insisting that it's good that we are here and it's good that now the public is listening to me. But the fact of the matter is, will this be worth the money which we've spent up to this far?
Yes. Well, that takes us to paragraph 14 then. Or let's start with paragraph 13, maybe to put it in perspective, and then we'll go to 14. Can you read out paragraph 13?
Any objective, fair and reasonable analysis of what has occurred during my incumbency until this point can only lead to one conclusion and one conclusion only. I'm not guilty of the charges concocted by Honorable Mazon of the DA and supported by the ANC majority. On the contrary, I have taken the office of the Public Protector to greater and unprecedented performance and governance issues pertaining to proper accountability.
Yes, thank you. Okay, let's just pause there. You have indicated that this, as far as you are concerned, is a what you call the special project. Yeah. But let's talk about the second part of that statement. Again, I think given your most ardent critics, even Mr. Samuel, of all people, have said that you have indeed taken the office to greater heights. Can you just tell us, we will come to this when we deal with the so-called HR issues, but some of the issues that, sorry, I just want to fast forward to, it's fine, we'll come back to that. I wanted to dispense with another section that we're going to deal with. But let's just talk maybe just about governance. Let's leave out the other performance. Everyone knows about the 3 clean audits in a row, unprecedented. None of the quote unquote giants that preceded you could achieve even 1 clean audit. What drove you to that and how did you manage it, that miraculous feat?
The first thing which we did, I indicated earlier that our mandate is to investigate undue delay, discourteous behavior, improper conduct in state affairs, the way it's so wide. And we cannot be going around investigating state institutions when we ourselves are guilty, or we have investigations which are not finalized for 10 years, for 6 years. So we then decided to just prioritize that, because, you know, when complainants feel disgruntled, when they knock at all the doors and they come to us, we treat them like that. That's why you'll find them even breaking windows and, you know, behaving like that. And it was not the first time. It happened when I was 2-3 years in the office, when one of the complainants reached that level. And it was a question of saying, when they come to us, let's make sure that we listen. There's nothing which makes a person happy, just to give them an ear. And even if you won't be helping them, but at least listen to them. So secondly, there were a number of issues which I've found there. It was not possible for my predecessors to have a clean audit, or especially the first Advocate Matonsala, because when I arrived there, there was a forensic report where they had outsourced investigations to various firm of attorneys. There was a lot of violations of the supply chain management policies, treasury prescripts, and that was making them not to be able to have clean, or there were a lot of material issues, which when we were trying to resolve them, Auditor General, when they come audit, and those for the accounting officer and the CFO were the key challenges, because and they would say, no, you need issues of consequence management. Those who conducted those, they need to be disciplined. And as well, we need to get a condonation from National Treasury. When we wrote to National Treasury, it was a delay. So finally, when we were joined by Mr. Busisiwe, who had experience and worked in Treasury in the past, that's one of the things which he said, this we will achieve. And indeed, it was a team effort. Somebody will say, but no, that's an accounting officer's responsibility. But you will never have an accounting officer, because it depends on the executive, which will have to make sure that they have an oversight on how the operations of the institutions are being conducted. Because it's one thing to have an accounting officer who will follow the PFMA to the latter, but then you have an executive who's a minister or a board chairperson or a board who will then spend or demand that you appoint people without following prescripts, or demand that you appoint companies without following prescripts. So hence we had to make sure that, myself included, we also act accordingly. I don't demand things. I don't even, because that was an issue of also, there's two firm of attorneys, I think it Adams and Adamson and Gilfil, and which were used by the institution over and over. And there was no panel of attorneys, where we had to say, insist, firstly, we utilize the IEC panel of attorneys as a Chapter 9 institution. Then later, we had to advertise and appoint our own, or have a panel of attorneys, which we had to utilize. So those are the small things which we did with the team. Hence, it was a team effort. It was not only my achievement.
Yes, thank you. Yes, I think if anyone goes through your statement and at your insistence, and if anyone goes through your evidence, your oral evidence, and do a word search, the word that they will find the most frequent is we. So explain that, why everything you get all the credits about, clean audits about, reducing the backlog, about all the things that you have been credited with here, staff morale, you know, and so on. But you always insist that it should not just be attributed to you as an individual. Can you explain that?
You know, it's understanding, though I've been portrayed by those 15 witnesses. It's as if I'm this monster of a person. And when I joined the institution.
No, I have to defend the witnesses. I think out of those 15, maybe 8 of them said that you were the best boss you ever had. So
okay.
let's.
Yes. So the issue of working with a team. I mean, you've had some of the witnesses, Bo Tebele, Bo Mataboge, Vuyana, and them, who were saying they conducted the investigations themselves. So, and if you think how hard they work, and myself included, that we finalize the backlog, we should be leading by example, as I said, because that's our core, that's our key mandate. And when we issue reports, it's a collective. When the backlog is reduced, it's a collective. And they are professional in their own spaces, because I wouldn't just claim this work alone. yes, I was the driver or I was the leader of this team. As a collective, we managed to do that. And coming back to the issue of consequence management, I know we're still going to deal with those issues because when Auditor General checks your systems, your processes, your delays, your violation, irregular expenditure, and not complying to your own policies, they always will be saying, what steps did you put in place? And consequence management. And consequence management doesn't mean that you would be dismissing people. Consequence management, you'll mean you have to make people to account, because how do you learn without taking accountability, without being asked for the reasons? Why did you delay to finalize this matter? Why did you procure this without following the procurement processes? So that you can then, in a way, a little bit, while you will be changing and understanding that this is how I should be dealing with the matters. So it was not my work. Yes, 6.5 years, we work as a team. And I'm proud to say that each and every member of the Public Protector Office has put their all in making sure that they deal with the complaints and the poor and the marginalized, and they change their living conditions. So it's frustrating, Kona, to see that I'm now charged for incompetence. I've never brought the country to 8 hours of load shedding and affect businesses and affect livelihood of people. Some people are dying in hospitals because there are no generators and everything. But I'm sitting here, was trying to change the lives of the people, and I'm being treated like this. Maybe because I'm not the right color. I don't know. Yeah.
Thank you. Maybe we should, if they don't want you in Public Protector, we'll take you to ESCOM.
Yeah, I can make a big difference there.
Thank you. We need that. Thank you. No, now you said that, no, well, it's true on a serious note here. It does make a difference that you're of a particular color and of a particular gender, but that we will leave to the members of the public. And how do you feel then when some of the people you are talking about who have done that to the country are praised as heroes, while you are condemned as a pariah and be a victim of a cruel witch hunt such as this one?
I feel very sad because, I mean, with all the persecution I've been facing, I remember even from the media, there was a stage when I was labeled possibly, am I the enemy of the state?
Yes.
Financial Times
Mail.
showing me as this Medusa, ne?
I think it was the Financial Mail, yeah.
Mail,
Wait, I
yes.
don't know if it's part of the documents, but yes.
Yeah. So, you know, and you trying to uplift people, you are trying to show that there are these root causes in the system which generation after generation, you'll still face the same challenges. And you find people who are performing badly. I think in South Africa, there's that challenge. Uguti, when you excel in your work, you will be vilified, you'll be treated badly. And hence I'm saying I've counted or I've checked a lot of Black professionals, the way they are being treated, and who've tried to change the living conditions of the people are treated like that. Hence I'm saying it feels very sad to be treated like that. And when you see other people who are performing badly are then promoted or are then held to high regard.
Thank you. Now, before we come to your personal credentials, I just want to round off that issue about, you say somewhere that you wanted the and we will deal with that when we deal with Vision 2023. You wanted to leave the institution in a much better place than where you found it, and you wanted to do a smooth handover to your successor. Unfortunately, you're here wasting time while the public is left without its public protector. But just to put that matter into perspective, you say at paragraph 86, I'm just jumping to so that we round off that point. You describe the conditions which you found there. That's page 38, big page 534, what's up? Yes. Can you just describe the situation that some of the challenges that you found there, maybe by reading 86?
To my dismay, I found the institution in some state of disarray. I had to hit the ground running, literally. Not having received any job specification, no training, exacerbated things. Some of the issues which I identified as concerning included massive backlogs in respect of different types of categories of cases, especially the bread and butter issues, because what we call administrative justice and service delivery matters, the numbers were higher. The shortage of staff shortages and the staff shortages also then will deal with, we should have said staff shortages, human resource related challenges, security clearance issues, which was one of the key issues I've picked up when I arrived there. Persistent governance issues and audit queries. I've mentioned the issue of outsourced investigation. There's a report, I think we've uploaded the OMA report or forensic report, which showed a lot of gaps in the system. Low staff morale. I think even Hamilton Samuel indicated that on that issue, they were taking the institution to CCMA. I intervened, made sure that they also their issue of occupational dispensation processes or payments is resolved. There was some files which are missing information or we are not getting evidence. I mean, I think on the CX we'll deal with it. Some of the information was not there. Then there was issues of transformation and affirmative procurement, especially in relation to legal services. For instance, the repeated utilization of the same white law firms without a panel of attorneys in breach of Section 217 of the Constitution and the regulated the regulated framework.
Sorry, on that one, we know that I think Advocate van der Merwe considered that all the work there was, as you said, outsourced and to the mainly white firms. How did that affect the performance in terms of the imperatives of transformation and affirmative procurement?
That's one of the things, especially because the Auditor General picked up that and flagged it. And it was one of the things which we should have resolved. And I must indicate that as a learning institution, we had to change, we had to be compliant, we had to make sure that this is not recurring, because there was then an advertisement to open up the space to allow all the firms of attorneys to apply to be on our panel so that they can be utilized. So that's one thing which we did as an institution, because it was wrong that we use only 2-3 companies and which were doing cases. Some of them, they were never stopped immediately, I must indicate. you know, because the matters were still in court, the matters, they were still following up. So it was not a question of just stopping them, but we had to do it systematically, because understanding that now they understand the nitty-gritties of that particular matter, but we had to change that because it was wrong. Payment of service providers in terms of treasury regulations.
Yes, no, sorry, it was still on 86.7. I wanted just to, I know I'm not giving evidence, but I want to preface this by you explaining to the committee why you have a passion for this. I've been in the legal profession for a number of decades, and I'm happy to say that I've never met a leader of any institution in this country or minister or anything like that who's committed, so committed to the issue of ensuring that Black lawyers in particular and are given an opportunity, and also women. So for those who don't know, it's because of your insistence that you have a team like this. For example, as we're sitting here, majority women, and why you take those kinds of things so seriously and insist that you know, unlike your predecessor in particular, that Black people in every profession or service provider sphere that you deal with, despite all the noise and nonsense, that to show what drives you to do that? What makes you such a champion of transformation, both in terms of race or gender?
You know, I think one thing I normally say is that because of the inequalities in South Africa, well, I mean, the issue of inequality being one of the key issues, because always we're trying to deal with the issue of the triple challenges. I've said that during even my interview, inequality, poverty, unemployment. Every opportunity which one gets, I mean, why pay a lip service and say we have this constitution, we need to uplift the poor, the marginalized? And I think we're still going to deal in a Vision 2023, because for me is, how do you empower a person to such an extent that they can stand for themselves instead of you know, just leaving people or not empowering people? Because by doing this, how many families are you empowering? Because for me, I also was exposed to a situation where illegal profession, and of having seen some attorneys as well marching to the union building, saying state attorneys is not giving them opportunities and work. And how do we utilize the state institutions to assist in the issues of transformation, but assist in the issues of economic empowerment? So this was one of the areas which would also assist in empowering the people. And I mean, a lot of the matters we're dealing with are constitutional and administrative matters, service delivery related. So if you then give a Black company or a Black advocate, who would also sometimes they would understand the environmental issues which people are subjected to. Because if I gave the vendor pension matter to Advocate Ngalwane, who would understand the impact of not reaching a solution to that matter. After my predecessor issued a report, I issued a special report. So to me also, it was a question of just empowering them. And it's still my passion. I will do it over and over. Unfortunately, in this committee, then it was portrayed as if, you know, there's ulterior motives or some lawyers are benefiting where they have done the work and they've excelled in what they were doing, and not to say they were just paid for not doing their work. So hence, I've been intentional in doing this, and I will continuously do that.
Thank you very much. And for the record, all those victories that we talk about in the morning, whether it was about advising Parliament that there should be rules, whether it was about the issue of legal representation, whether it was about the suspension of by the President, and all those you delivered with black brains, and all your opponents in all those cases were this Parliament and of course the DA had where on the other side had the exact opposite. So I think it's something to be mentioned. All right, now you go to 86.8. It said payment of service providers in terms of the treasury regulations. What was that as a challenge?
It was a challenge, not paying service providers within 30 days. I mean, that is very clear. Again, that should be driven by each and every public servant. Because if you don't pay a service provider within 30 days, you are violating the laws. But secondly, you are then creating financial strain. There's a number of small businesses which are suffering. They are not being paid on time. And this, I must say, SC and Chairperson, it also perpetuates issues of corruption, because you find that a small company, SMME, has performed, they are not paid on time. Some are expected to pay Biola, which is a bribe, so that their payments can be fast-tracked. That time a person has conducted or has performed. So as an institution, we cannot then be doing the very same thing which we are investigating out there. Hence, we had to make sure that we comply. And that drastically changed, because it's one of the criteria or the requirements which Auditor General was checking, so that we can excel, and it will also change a number of livelihood of those small businesses. But a lot of businesses, they just are driven out of business because they perform, they are not paid. How do you pay your workers? How do you order any stock and stuff like that? So it has that ripple effect. So we had to make sure that we change that.
Thank you. Then the 86.9, you talk about one of the challenges, excessive reliance on consultants in respect of core functions. For example, as reflected in the OMA, I don't know what that is, forensic report, which was uploaded under bundle H, item 14, page 341. Okay, let's forget about the detail. You talk about excessive reliance on consultants in respect of core functions. What was that? Can you assist the committee to conceptualize that as a challenge?
Yes, there were a number of reports which were outsourced. The public protector is allowed to do that under Section 7, subsection 3, to acquire the services of either the secondment from other departments or any other companies. But then the problem here was that the outsourcing of those investigations, it was not clear the terms of reference. Some of the firm of attorneys and companies were paid. I mean, the arrangement was that they should be paid. I think the arrangement was 70,000 per investigation, but some were paid more than that. Some were even paid without delivery of the service. So it was a wasteful expenditure, because they conducted the investigation, they didn't submit the report. So this is what it means. But then besides this OMA report, I mean, when I was presenting the report of my predecessor at Parliament, hence the accusation that I was, as if I'm painting her negatively, but it was the report which had information that the some of the consultants which were utilized was when the state of capture investigation. Remember, they approached National Treasury for the funds. There was this auditing firm which was also engaged. They were working with, I think it's Ernst & Young or PricewaterhouseCoopers, but when they were conducting that particular investigation. So you can do that, but the issue is, what are the limitations to that? And I think my passion then being the issues of security, I think it was very critical for me to refrain from doing that.
Good. Then the last one you put as misalignment of meetings and unnecessary traveling time. Can you briefly tell us that as a challenge that you found?
You know, the famous think tank meetings, which I was accused of stopping, and it was, you know, a very operational issue which was blown out of proportion. And unfortunately, we had Miss Mutsitsi who came here, who was once an acting CEO, where we were checking where can we cut and, you know, save the costs. Because the issue was, you come, think tank was every quarter. There's various investigations which they come and present our provincial representatives. They come, they leave their investigators. You find there's lots of gaps. They present those reports. They are not up to date. You send them back. They go back to their offices, work continue. 3 months, they come back. Things are not done. Those things are still pending. And there was a stage where we said, okay, possibly then come bring along that senior investigator so that we can engage with them directly, but it's traveling costs. We don't have resources. So there was a stage, then a decision was taken that, okay, let's minimize that. Or we also tried to say, Western Cape matters are not going to be presented by Western Cape. Send those drafts to the Eastern Cape team. The Eastern Cape must present so that we can see whether they can cross present so that we promote the issue of speedy dealing with matters and quality assurance. That failed. Hence, then I decided with the leadership, see the then accounting officer, let's limit that. Let's only have a small team, which was in my office, Sabo Matlawe, Kekana, and I think Dicheni sometimes, to deal then with those, because a lot of the reports came from that think tank. If you check all the what is posted on Dropbox, the think tank, and then register, the task register, which Debele spoke about, they were coming from that. So we had to save a lot of money. And then we said we wanted to have a teleconference, and deal with these issues, which we did in a number of instances, which also helped to reduce the traveling expenses. So it was a lie that we had to cut a budget, outreach, because the outreach, the very same tourist thing was saying, I was working in Home Affairs as a regional representative, or as a provincial director, chief director in Limpopo. We can do this. We can create a district model and make sure that instead of dealing with individual municipalities, you deal with them as a district model. Then we save on you having to do outreach to a few people in one local municipality, but then do it in a broader district model. So those were mechanisms which were there, because if you speak about the issue of unnecessarily traveling, person will be traveling to one area, meet less than 10 people. So we were saying, instead of doing that, travel to an area where you have all the local municipalities in one district, then you at least meet a lot of people, and you will be impactful.
Yes, thank you. Thank you. Before we move back to the where we were in the statement, I was just going forward because it linked up with the issue of the issue that you had raised of how you found the office. Do you think, because apart from your passion and all the things that you've said, your passion for transformation, for delivery, for the poor, improvement and so on, compared to your predecessors, I mean, it's light and day compared to all your predecessors, not just in the area of clean audits and backlogs and all that. And one has to find something more than, as I say, your obvious passion for work and hard work. Do you think one of the secret ingredients is the fact that you, unlike anybody else who had occupied that office, actually had worked there as an investigator and you knew the environment? So you were able, for example, you tell us you found a report there that had been sitting for 6 years and you did it in 9 months. To what extent, really, is the question? Can you please tell the committee in your own words? Did that experience of having worked there on the ground contribute to your excellence?
I'll start by saying, I think it's the issue of whatever you do, wanting to serve whoever you can serve without even expecting anything in return. Another benefit was that, as I said earlier, I worked in a human rights related environment. So working there, yes, it was very helpful that I worked as a senior investigator in the public protector.
Yes, can you please, I really want you to take the committee into your confidence as to what edge or advantage that particular experience gave you of having, I think we've had 4 or 5 witnesses who have said, I knew the public protector because we worked together as investigators and so on. Then when she came back, it was easy to relate. We've had so many accounts. And in my estimation, that is something that maybe that's the magic answer. Can you just tell us how it was to be there at the bottom and then now to be able to relate to those people who are at that quote unquote ground, at the ground level?
Yes, I think the first one is that serving, but then secondly as well, I knew the operations of the office and how to conduct the investigations. That's been my strength throughout my work environment, because I'm this person who, when I get into an institution, I wouldn't want to not know how the system works and how to process any application. I mean, working at Home Affairs during the Zimbabwe uprisings, I was at the director level, but I had to fold my sleeves and process asylum seekers. Working in China, when it was very critical for me to put things aside, is to know the system and how to process applications there. You know why that helps? If you work in a service delivery environment, or that as well is, I'm encouraging everyone. If you are a director, a DDG, or well, all our DGs and DDGs, we are like that in public service. I remember we were laughing about CE and ACO. But then I think the minute you do that, you won't have a situation where a senior investigator will come back to you and say, no, public protector, this is not possible. Because you've been there and you know it's possible for you to do that. So I think that helped me, because I never behaved as if, no, I'm the executive. But maybe that's why sometimes then people felt I'm encroaching a lot into their space. Because for me, it was purely to make sure that we deliver on time. And again, not for our selfish or numbers that we've processed so many, but whatever we've done, what impact does it do to the person which we are serving?
And well, On a lighter note, when you were just an investigator there, did you ever think you will be the public protector yourself without, if that person had not nominated you?
Definitely not. I mean, I never thought I'll be the public protector. For me, I worked under Judge Bakwa, and I never thought I would be the public protector. I worked under Advocate Mushwana as the senior investigator, and then he gave me an opportunity to be the acting regional provincial representative. And I think one comment which was made by PP Sokoni from Zambia, who said some of the witnesses, well, when they came here and some of the issues, he was saying, hey, now when you say you worked in that institution and those people were your colleagues, now you come back and you are their executive, possibly some people might not take it kindly. So possibly that's why you will never be, because I think you remember Samuel saying I was just a trainee, or I was fearing the issue
Senior
of
prosecutor.
yes, and
Aspirant
yes,
prosecutor.
and I was scared of challenges because I stopped a think tank, and the think tank, I was stopping it because I could see that I wouldn't allow a process with the accounting officer saying we don't have money, we are not delivering, people are coming, staying in hotels, claiming a SNT, going back, it's as usual. You have Busisiwe who has lodged a complaint, it's 2 years, 6 years, nothing is happening. So I think I was driven by that. So it was by the grace of God that I went back to this institution to assist whoever can assist.
Thank you very much. Yes, no, I think that assists a lot for us to try and find what your secret, what the secret is to your successes. All right. Now, at paragraph 14, if you can just go through those items, sorry, the 503. If you go to those items and then speak to them, you say, oh yes, we've spoken about the unprecedented performance, and that's what we were unpacking now. So paragraph 14, can you read out and then you'll take us through in the same way without too much elaboration on each of the points?
Okay. To put matters into their proper perspective, I wish to point out the following glaring absurdities. My 7-year non-renewable term of office will expire in, I think in 6 months' time, October the 15th, 2023. Based on past experience, within the next few weeks or days, they might be advertising the position of a public protector, shortlisting and interviewing for the next public protector. And that process, I think, will commence soon. And the current inquiry, which we're still not yet sure how much it costs. I think I spoke about it earlier, but one member said around 1 million per day, including the non-financial cost to the public for the instability cost in the office, which is incalculable. I'll expand on that later.
Right.
Contrary to the popular and false narrative, my legal team and I have been to courts on countless occasions, making several attempts to stop the commencement or the continuation of this illegal process, which we've shown several times that sometimes we are rushing and we might end up with a process which will have to start afresh. So I've mentioned the Constitutional Court. Currently there are 2 judgments which we are awaiting. The full court of the Western Cape High Court, the judgment was reserved, and the Constitutional Court respectively. So on each occasion, the president, the speaker and the chairperson of the committee and or the DA have opposed all efforts to stop this costly and pointless and futile exercise. Again, hence I said that I'm sitting here with those charges which I've explained how they came about.
Right.
So the witness called by the evidence leaders and the committee alone have effectively exonerated me of any impeachable wrongdoing.
Sorry, Chiba. Can you just either
The
close the,
witness called by the evidence leaders and or committee alone have effectively exonerated me of any impeachable wrongdoing in respect of any single one of the charges. No fair court of law can possibly uphold the contrary finding, which will inevitably be made by the current DA and ANC overwhelming majority in the committee. The impeachment effort is therefore doomed to fail if subjected to any fair judicial scrutiny.
okay, can we then go back? So the first 2 points you make is that your term is ending in a few months, and the interview cycle is scheduled to start. How do you know that? What happened in your own experience the last time when you were an interviewee?
Yeah, I think around 2-3 months time, indeed, it will start. They will advertise the position and start with the interviews. Indeed, that's what transpired during the process when I was nominated. And the question is, members of the committee and the public at large, is that the outcome, or is that the process we would want to pursue going forward? And I should be in the office, making sure, in fact, I've been saying that when the process of me, like last year when we were doing a lot of meetings, going through the investigations, coming up with a new model of how we are conducting investigations, I was always saying to the team, this is my last year. I would want to make sure that my successor would come to this institution and they just find that we don't have a backlog. All the matters are still within time. Then they will have enough time to, do their work, come up with their vision and proceed with that. So it was purely that. And I wanted that process to be so. So now the issue of the resources, when the office has written a letter that they wouldn't be able to pay the legal cost of my attorneys and legal team, and because they don't have the resources.
Yes. And all right. So yes, I think my team did check what happened the last time. Yes, you're quite right. The process of advertising usually starts around March, April. So we can expect it at any time. But anyway, we're here now. And the good news, as you said in the morning, is that you've had an opportunity to speak to South Africans yourself, which you've been so eager to have. Now, we've already covered what, if there's 2 cases where we're waiting for judgment, if there's findings in your favor once more, then this process will have to be started from day 1. In other words, every cent we've spent on this would have gone to the dustbin. Paragraph 15 we've covered. That's where you were referring back to why you are participating in protest. We've covered that in the morning. And then if you can go to paragraph 16 and then maybe take us through that before I go to your personal CV.
So this one, I know you are leading me, SC, but then there's that paragraph 4, which
Sure.
deals with the rule 1298D functions and powers of
Okay,
the
so
committee.
thank you, sorry about that. Well, I might be leading you, but it's your statement, not mine. So we can go to paragraph 4 as a preface to this, yes.
Yes.
Yes, paragraph 4, that's where you were explaining the situating the issue of fairness in particular. And maybe I don't know if you want to paraphrase it or maybe you should read it out.
I think for the members of the public to understand that the
Good.
functions and powers of the committee, in terms of rules of the National Assembly 12980, the committee must. So it's a must.
Sorry,
They don't have
maybe
discretion.
sorry, PP. Can you just maybe read the whole paragraph because the rule is situated within that context.
Yes, from the beginning.
Mm.
So the purpose of this affidavit is to outline to varying degrees of detail some of the key issues which arise from more than 60,000 pages of documentary and other evidence which has so far been presented as forming the basis of the charges laid by Ms. Mazone, MP, against me, which therefore in turn form the basis of the accusations whose veracity the section 1941 committee is tasked to establish in terms of rule 129AD of the applicable rules of the National Assembly, which states that the functions and powers of the committee. The committee must, when the Assembly has approved the recommendations of the independent panel in terms of Rule 129Z, proceed to conduct an inquiry and establish the veracity of the charges and report to the Assembly thereon. So
Okay.
it's
Can you
establish
pause
the
there?
veracity. Yeah.
Yes. When that rule says that this committee must, then the Assembly has approved the recommendations of the independent panel. What do you understand by that? Because the committee seems to understand that to mean that they must go back to the original Mazoni panel. So irrespective of the recommendations of the independent panel.
Again, that is going against the rules of Parliament. And remember, the panel was also appointed by the Speaker. The panel was paid to do the work which they've done. And the panel had findings of prima facie evidence, which was based on paper. And the panel had other issues which they said are not supposed to be dealt with, or there's no prima facie case.
Yes.
I mean, the issue of Baloi, the issue of
Pillay.
other human resource related issues.
Yeah.
So
and Pillay,
and the issue of
Baloi and Pillay, they said
Yeah.
there was nothing.
Yes, so that's what the panel was what did, and that's what the committee should have looked into the matter. So unfortunately, the scope of the inquiry then was expanded because this committee, their directives, then they focused on the original Honorable Mazoni's motion, which then expanded the scope of this investigation drastically. And I think we are 8 months to 9 months here. And if we only focused on those few items which were recommended by the panel, possibly we would have been very far with this particular matter. So then 2, it says the committee must ensure that the inquiry is conducted in a reasonable and procedurally fair manner within a reasonable time frame.
Okay, let's pause on that one. So the committee also has an obligation to ensure a reasonable and procedural fair manner. Do you feel that you have been treated reasonably and in a procedurally fair manner?
I have not been treated fairly. I will say, firstly, we indicated, or I indicated during my first appearance on the 11th of July that I'm participating in this committee under protest. I remember when I was suspended, my emails were closed. I couldn't access them from the 9th of June, I think, until the first week of July. I couldn't access my emails. I couldn't access certain information because there were key critical information from that. And then we raised the issue of Honorable Mileham within a week after the proceedings have started, after discovering, because honestly, I didn't know that he's the spouse of the complainant, Honorable Mazon. And there were still pending cases, which we were pleading with this committee to say, can these matters be dealt with before we can proceed? Well, the scope was expanded. The refusal to amend the directives because we gave our own inputs. The treatment which the legal team has been facing, because it's a question of how each party is allocated the time frame to cross-examine, to determine the veracity of the allegations. And most of the time was any matter or objection we were raising, I think it's out of 10, possibly 2, which we were given an opportunity to, or were accepted to our favor. So when all those things were happening, I was just hoping that it will change. But what then the last straw was the inhumane treatment, which I still say today, when I was feeling sick, when my legal team was raising the issue of requesting the postponement because they were going to be busy with the legal, the court matter, then they were given that. But when we raised the issue that we cannot proceed because I am not there as the accused person, I need to be present, I'm sick. But then the committee proceeded to examine or ask questions to Ms. Tejani. And I think I felt as if it means I'm not human. Even, hence I said even earlier the last time, hardened criminals will be given that opportunity, but I was never given an opportunity. So the buildup of all these issues, unfortunately, makes me to feel, because it's what I feel, Oguti, I was never given that opportunity. Whereas there was a time when my legal team were not present, the committee proceeded to hear the evidence of Niels van der Merwe, because at the end of the day, there would be opportunities for my team to object live, to raise issues with the chairperson and the committee, but that never happened. So I think this is a learning curve. I'm here, I indicated earlier, I'm being used in this process. Everyone is learning. The world is watching. I think the public protector Zambia said it. Whatever happens in South Africa, unfortunately, as Africa, it replicates to us. So I think they should be learning. They should know in the future that if such process is conducted, be as objective as possible and make sure that you are seen to be objective, because it's a question of everyone following and watching. But unfortunately, Mina, that's how I feel, and I still feel like that, Uguti. I never received any assistance. It was worse. I mean, finding women like Honorable Gondwe proceeding as if that person, well, even if I had a heart attack or I died that day, it means to them it was nothing, because they're rushing to this within a reasonable time frame. But here is a reasonable and procedurally fair manner. within a reasonable time frame. And I mean, if you can calculate how many times we requested that we be given an opportunity and how many times this committee also took their time to conduct their committee work and the break between those times. So I think, yeah, it was not a fair, or I didn't feel it's a fair process because we are checking who is in the fire here.
Yes,
Yeah.
thank you. Now, okay, I think we mustn't brush over that point. So indeed, you are saying that it was reported that you were sick and indisposed. Nobody knew how sick you were. As you say, you could have been literally dead. It's not an exaggeration. You could have had a small headache, or you could be comatose. We didn't know how sick you were. But the committee decided to continue with a witness where you could have been literally in a mortuary for your impeachment of that dead person. How fair can that be? Or is there any reason you can think of under the sun why any committee of fair human beings could treat a fellow human being like that?
You know, that's why sometimes I would say the way I'm treated in South Africa. I was a director and an acting chief director at Asylum Seeker Management. I used to joke sometimes and say, you know what, maybe I must apply for asylum from another country. Because also that made me feel bad. It was very much hurting, I must say, to be treated like that. And worse, it's when you were cross-examining some of the witnesses and when they are saying bad things about me, and you trying to go to the veracity of the information, and then you come to the issue, but what if she also had fears? What if she also wanted to deliver the best she knows how? And you got a clean audit, and they claim they had clean audit, but they don't want to accept that we had to go through that process now. And as I said earlier, you know, there was one stage where I don't know whether you saw me. Fortunately, we were doing a virtual platform. We were on a virtual platform when Utebele was testifying. Well, I cried literally because
I did see that.
Yeah, I felt Guti. I went all out for this country.
Chair, I propose a 2 minutes break.
Yes, thank you, Mr. Mwala.
No, wait. Are you proposing?
It looks like the witness is not in a right space, so I was proposing
Thank you,
at least 5
Honorable
minutes break.
Mwala. Thank you. We're about to get to tea, so at 27:30 now. We'll take a tea break.
Thanks, Chair.
For 10 minutes, back after 10 minutes. We pause for tea. Thank you.
Thank you, Chair. Thank you, Deputy Chair.
Recording stopped.
Welcome back, colleagues. We're waiting for Honorable Mwala. We now can start. Over to you, Advocate Mpofu.
Thank you, Chair. Thank you very much, Chair, for the break. Advocate Mkhwebane, I'm going to move to a lighter topic, I think, for obvious reasons. And I just wanted to say that let's walk this journey. It's going to be fine. As you said, you are doing it for generations to come. So, and I just want maybe to register that in this whole process, as you said, it's only twice that I've seen you breaking down. The first time was when Mr. Tabele was testifying, and ironically, he was probably the most complimentary witness about you. So, but when all the other people were insulting you, you were able to be strong. And now this time when we're talking about how people were prepared to continue with the witness, even if you could have been on your deathbed. But it's fine, we'll get there. So let's move to paragraph 56, just so that we could deal with lighter issues. We'll come back to how you felt about the historical unfairness that you've experienced in this process. So maybe this will bring back good memories, University of Limpopo. Right. You hold a BProc and LLB degrees from the University of Limpopo. And you also have a diploma in corporate law, as well as a high diploma in tax law, both from the University of Johannesburg. Is that so?
Yes, it's correct.
Yes. And you make the point there that at the time of your assumption of office, you were in your 20th year as an admitted advocate of the High Court of South Africa. And they also make the point that we were told that such qualifications are immaterial. But you're saying this fact is material to your position, since the relevant legislation prescribes for any person to be eligible to serve as a public protector, he or she must have been admitted advocate on attorney for a period of at least 10 years. Having been so admitted, do you know why this House, this legislature, would have made such a stipulation that a person must have been admitted for at least 10 years, or a judge, or all the other things that get put in your advert coming from legislation? What is the significance of that for the position that you hold?
Yeah, it's very much important to be the, admitted as an attorney or an advocate. And the critical issue is that that 10 years, you should have worked in the environment where there's administration of law. Besides the issue that a person was not practicing, or a person is not possibly in a position where they are, yes, a practicing attorney or a practicing advocate. But then what is critical is that you should then understand in a broader sphere how the operations of the state are. Because as a public protector, you are, there's where we indicate, or I indicate, that we investigate more than 1,000 state institutions. And I mean, if you investigate, let's say, home affairs, you're not only dealing with the birth and registration legislation, but then you'll also be exposed to Citizenship Act, you'll also be exposed to Marriages Act. So you need then to understand how the applicability of the law operates. So this is very much critical that a person should meet these requirements.
Yes. All right. Okay. Sorry. I said that just for my own understanding that it is something that's important. But anyway, would it also assist you, that understanding of the law, to know some of the basics really? I mean, such as the fact that you cannot amend an affidavit a day after it was sworn in. I'm just using that as an example because it happened recently. But do you think someone in that office, there's time to have to be teaching them that kind of basic first year stuff?
I think it's very critical and important to, as I indicated earlier, that, you know, when we also accept complaints from the complainants, when we assist them to complete those, when we expect them to write and sign for their statements, but then most of the time, as the public protector, we then taken to court, one has to sign affidavits, but again, it also limits the issue of being as opened up to any fraudulent utilization of whatever as a person you've put forth. I think what happened recently, as I indicated, that it was for the best of the professor, that for future generations, there is a statement which she made, which she acknowledged that she changed it alone after, which she knows herself that I think for the decorum of this proceedings, it should be something which is properly attested to. I think those are the things which we keep on learning, and especially when you are legally qualified, you cannot be blamed for being ignorant on some of the issues.
Yes. No, thank you. That's fine. No, those issues will be dealt with at the appropriate time and appropriate forums. But are you registered with the LPC? And please don't think that I'm being unkind. Again, so the chair, it says Legal Practice Council, it should be council. And yeah, are you registered with the Legal Practice Council?
Yes, I am registered. Though at first I thought it's not necessary for me because I'm not practicing. But then there was a stage where I was also approached by the Legal Practice Council, so that one, you are properly registered, but also I think such helps in situations, it should be helping in situations where one is facing such challenges and how they can assist and also keep the profession to become compliant and not to be exposed to a number of questionable conduct, as much as you'd find the auditing profession where they are having the profession which manages how they should be conducting themselves.
Yes. And you've put your LPC registration number there. I won't read it out, but so thank you very much. And I think that it's very important to and also understand this. It's painful sometimes, but we have to go through this. Whether these qualifications, which are, as you say, part of the statutory framework, the importance thereof. Let's put this matter into perspective. It is so that most of the people actually who testified there, who work in your office, are admitted advocates. Some of them may or may not be registered with the LPC, but the majority are legally trained, again, so that they know the basics, really. We don't have to teach them about the basics of forgery. And that for example, Ms. Bauer, I think, put it to Mr. Matabuche, mistakenly called him Advocate Matabuche, and he was just quick to say, yes, I'm legally trained, but not an advocate. No big deal. But what is the importance of that legal training and legal understanding, as it were, not just at your level, but with the people who actually do the spade work, shall we call it?
As I said, that it's very critical for them to be legally trained. A lot of them are legally trained, and at least when the complaints are lodged, when they have to investigate. Remember, I said we have to check what evidence is before us. What is the complaint? What is the evidence before us? What legal prescripts which have been violated or not violated? So for a person who's legally trained, at least they would be able to check all those. And I think the institution, the way it was, when I joined the public protector before, we were seconded from the Department of Justice, and it was purely only those who are legally qualified, and we were called legal administration officers. So thereafter, then during Mushwana's time, they changed the process. They had to then appoint all the officials within the public protector per the Public Protector Act. So indeed, it's very critical. Some of them are yes, admitted advocates. Some of them, they've been magistrates. Some have been prosecutors. And then some would say, I am trained and I would want to be called a forensic expert, but at the end of the day, to be legally trained is critical and to be addressed accordingly. I know others are admitted attorneys, and always they would write that when they sign anything, admitted attorney or admitted advocate, or they call themselves advocates.
Yeah. All right. Well, thank you very much. All right. Now, the other issue, and I suppose it links up with the question that we spoke about earlier of you being having had the experience of working at the Public Protector's Office. You also say at paragraph 57 that you were also a public prosecutor between December 1994 to 1996, and also moved to KwaMhlanga Magistrate Court to be also as a public prosecutor. Again, very briefly, in terms of who is Busisiwe Mkhwebane, the journey that brought you to where you're sitting there now, what learnings did you have from being a public prosecutor, and just that particular perspective of the law? You've spoken about being involved in tax law and various other aspects of the law, but particularly that cutthroat adversarial criminal law experience of also being able to assess evidence. Can you just tell us briefly how that added to your current degree?
You know, well, in my other profiles, I indicate that I was funded by the then Gwandebele government to study at University of the North, TEFLOP. And, you know, when they were funding you every June and December, when we are closed, we used to work in magistrates' offices. So I only put the 1994 to 1996 as a prosecutor. But I started working whilst I was doing third year, fourth year, as a maintenance officer, and as then a public prosecutor. Maybe that's when Samuel thought I continued to be an aspirant public prosecutor. But that's what also exposed me to the administration of justice, to the criminal work. And you know, when you're working at the magistrate's office, that's where you receive a lot. Yes, it's minor crimes, your assault with intent to do grievous bodily harm. You wouldn't do your serious offenses like your murder and rape and stuff like that. But then you would find that most of the cases as well, like your some of the cases which needs one to decide whether you need to prosecute on them or not, you'd be exposed to that. But then also this then exposed me to the challenges of people accessing the justice system, and working there also made me to realize that yes, you can be the prosecutor, but then being a prosecutor doesn't just end there. It reflects the socio-economic challenges of each and every society, because you might find that you have a lot of maintenance cases. What are the dynamics? What are the social issues which are there? There's violence possibly. What causes that? So I think it's also helping one to contribute and change the status quo in the administration of justice.
Yes, thank you. And of course, this also gives you practical experience. In other words, you have actually practiced law, not just at university, because being a prosecutor for so many years is, I can tell you, probably much more intense than most people who practice in nice air-conditioned offices. How did that give you insight into the plight of our people?
Yes, as I said that, I mean, I was still at home at Kwaggafontein, working in Mkhwebane, and it's some of them we grew up with, but some you can see that it's the conditions which they are, staying under, which leads them to commit such menial crimes. Hence, that also gives one a broader perspective, which as a country, if you deal with such issues, you wouldn't find a person just going to commit crime, to steal, to murder, or to do anything. But I think you need to address where people are based, socio-economic challenges, whether a person is employed or not, and what influences them to behave the way they are behaving. But then if you stay around the communities, then it helps as well to see those and check how you can empower them going forward, besides just prosecuting them.
Yes. Well, thank you. Maybe that actually, I'm trying to assist the chair here by covering even some of the ground that is lying ahead whenever an opportunity comes. All right. Okay, it's not here. I thought it was here. The quotation from the Gantler case. But let's maybe link that, PP, to what you've just said now, which is quite significant. It's a statement that one would hear in a class of criminology about the root causes of crime. I wanted to relate that to the statement made by Justice Mkhwebane, Chief Justice in the Nkandla case, about the importance of root cause. Can you explain what, in your understanding, the duty of a public protector is in relation to this issue of root cause? And I can tell you now why that's important, because in the CX matter, you are accused of having, quote unquote, expanded the mandate because you wanted to deal with what you saw as the root cause of that whole thing about the lifeboat and so on, which was had to do with the mandate of the Reserve Bank. Why is it important, according to you and Chief Justice Mkhwebane, to have that mentality of not just dealing with matters superficially, but going to the root cause?
The critical issue with that, dealing with the root cause, when you go to the mandate of the public protector in section 182, where it says the public protector will investigate improper conduct in state affairs. The public protector is part of the Chapter 9 institutions who are there to support and strengthen constitutional democracy. And I think we're still going to deal with the CX matter SC, but what I would say is that the Nkandla judgment assisted us to also understand the mandate of this institution when it comes to issues of the root causes.
Mhm.
Because I think it's paragraph 68
Thank
of
you.
the Nkandla judgment,
Mm.
which dealt with how the public protector, when you investigate, you should check what are the root causes of the said maladministration. And when you issue your remedy, how do you deal with them so that there is no repetition of the very same issue going forward? So I think hence in all our reports, I think I can go there, where we deal with the issue of what the Nkandla judgment said
Mm.
about the powers of the public protector and to take appropriate remedial action. There is that thing which some people will say, but why you mentioned those key cases at the beginning
Mm.
in the morning,
The
5 cases. And if you see all our reports, and as well to show that we are a learning organization and under my leadership,
Mm.
is that the court judgments,
Mm.
how do we continuously put them in our reports? I think Honorable Sukras was asking, what are we learning from the court judgments? So if you check each and every report
Mm.
where we mention that a remedy should be addressing the root causes.
Mhm.
And if you address the root causes, you will never have to have people coming back to the office to lodge complaints about, let's say, Home Affairs or about, for instance, Department of Labor. Because if we issue that report with remedies, a proper organization, which I normally would say that it was only one CEO of weather services.
Mm.
When he was appointed, he wanted a meeting with me and said, you know, public protector, can you tell me which reports have you issued against this institution?
Mm.
I want to make sure that whatever you've recommended, because that person understood that when we issue a report, why they would learn from that report so that we don't repeat the same thing. And Judge Mkhwebane in paragraph 68 saying,
Okay, just a minute.
so I
Thank
think
you.
it's paragraph. It's
Yes,
page
it is paragraph
56.
68. I've just found it. Thank you. Thanks to you. And we used to call it in my classes of knowing the paragraphs.
Is there something you want to emphasize? Because you did take us in the morning through that.
No, not that particular paragraph. Okay. There is. No, I just wanted to put it up here, but it's not necessary. I can just read it out. Just for the members. That's fine.
Tsepo, please do.
Thanks. If I forgot.
It's paragraph 134.
No, 68.
No, I'm saying in my affidavit.
134. Okay.
Yes, paragraph
Okay,
138,
let's use
page
that one.
56.
134. That's fine. Let's use that one. Well, yeah, I think that's easier, Chair, rather than using the one in the court case. It's easier for the members. Yes. Okay. Can you go to, yes, paragraph 34?
134, yeah.
Rather 134, yes, paragraph. I think let's start at, read both paragraph 67 and 68 for the
Yes.
record.
Yes, so I was saying in all our reports, we mention these paragraphs SC, so that each and every accounting officer, each and every minister, or each and every person, when they read this report, they also would be educated. So it says the court further held that An appropriate remedy must mean an effective remedy, for without effective remedies for breach, the values underlying and the rights entrenched in the Constitution cannot properly be upheld or enhanced. So 68 deals with the root cause. Taking appropriate remedial action is much more significant than making a mere endeavor to address complaints, as the most the public protector could do in terms of the interim constitution. However sensitive, embarrassing, and far-reaching the implications of her report and findings, she is constitutionally empowered to take action that has that effect if it is the best attempt at curing the root cause of the complaint.
Okay, good.
So that's the intention.
Yeah, absolutely. Okay, that's good. Now, there's yes, thanks. Yeah, my favorite paragraph of your statement, which is, it's a very short one, but I'll tell you why, so that again, when we come to this chair, we don't have to redefine what remedial action is. Yeah, and I think this one makes it easy even for someone like me. You say at 136, in simple terms, to remedy is to cure. Can you go there? 136 is just a little bit, yeah. Very short paragraph. Says, in simple terms, to remedy is to cure, to correct or put wrong what is wrong. The concept has the same meaning as in the medical field. And I think for me that made it easy, because we think of this thing, remedial action is like some big word, but actually a remedy is discipline or whatever it is. It's to cure a root cause, a particular root cause. So, and if you go back to paragraph 133, I think again that the erudite Chief Justice Mkhwebane also gave us that simplification. He says that, okay, maybe read it, paragraph 65.
So
Of the Nkandla case.
Case again, in the above mentioned Constitutional Court matter, Mkhwebane CJ stated, among other things, the following: when confirming the powers of the public protector, complaints are lodged with the public protector to cure incidents of impropriety, prejudice, unlawful enrichment, or corruption in government circles.
Right. Now, can you then help us? I think that should clarify it even for a 3-year-old child, that the remedial action, you don't just wake up and give remedial action. You must have root cause, identify the root cause, and then try and cure it. So in the context of the CX matter then, when you identified the root cause, which we will get into when we deal with the CX matter, or rather, let me put it like this: when you suggested that one of the issues that needed to be looked into was the mandate of the Reserve Bank itself, which obviously went beyond that particular issue of the lifeboat. What got you into that? Because I know that you did research, you asked Mr. van der Merwe to do research and so on, that's common cause. But how did you get to that particular root cause that you identified?
I think my predecessor indicated the complaint of Mr. Hoffman, that the complaint was about the South African government having spent those, it was around how many pounds? It's just that I didn't read that part. Yes, and the question was that money utilized properly? But again, the other issue was whatever led to the South African government appointing this company was that the South African Reserve Bank was then giving loans and this gift to Bangkok.
Mm.
So the question was, and I think it was there in the drafts
Mhm.
of Livuani, when, if you can see, one of the proposals was change the policy
Mhm.
on how the Reserve Bank and National Treasury and the Bank Act should be crafted or be operationalized.
Mm.
Then during the investigation on analyzing the information, the key issue was how the Reserve Bank is operating, because the issue was going forward, how to prevent it. Then the interesting part, which we will deal with in the SCX investigation is that, or chairperson, when the Section 7(9) notice of the provisional report was served on National Treasury and Reserve Bank, then it was clear from National Treasury, I remember the official who responded, and I think she's still working in the Rebecca, that the legislation already has been amended and those issues will never take place. Then one had to check, where is the root cause? For me, the root cause then was, okay, let's conduct comparative studies to check in other countries, how are reserve banks operating and whether are their mandates captured in the constitution or in the national legislation, which will then allow you, as and when the need arises, you can focus the mandate of the Reserve Bank. And that's what then led me to go to the root cause. Uguti, this Reserve Bank, how is it structured compared to other countries? Hence, you'll find in the report, which we will deal with those paragraphs, and as well the research which Niels did, and just to check that. And if you can see even in evidence, that's where he's saying, I requested him to conduct that comparative study, because that's where the mischief is, where you have the mandate of the Reserve Bank in the constitution. And when you check a lot of other countries, the mandate is not in the constitution. The mandate is in the legislation. Then that makes your life easy, because you can change as and when the needs of the country are happening. So I know we will deal with those, we'll rebut that information, because the question was, why was she coming up with this remedial action? And because for me, that was the root cause of the problem. And I think there's a paragraph in Mkhweb's judgment on what is an appropriate remedial action or how to implement it. There's where it also says, paragraph 71, I think B, which we will deal with when we deal with CX, which will say, you, even as a public protector, you can direct the manner of implementation of your remedy, but I think we will deal with it. So it was purely that, and to see, Uguti, we have this institution. How can we deal with the root causes of poverty in the country, and what role can they play to change the lives of South Africans?
Yes. Well, thank you, Public Protector. We might as well, I know we will, I just don't want us to cover the same ground. So while we're here, let's deal with it, because this is critical, by the way. Most of the charges here are based on remedial action that you gave. And there are even charges that say that you expanded this or reduced this, which according to Mail and Guardian is exactly what you're supposed to do. But I think the critical thing is the failure to understand, Shame, that the public protector's powers are not circumscribed. In fact, as you say, Chief Justice Mkhwebane made it very clear that these powers are so wide. And although not unfettered, obviously, because no powers are unfettered, even the powers of the president. So I think let's go into paragraph 71 of the Nkandla report. What is the reference? No, the judgment. Sorry, did I say report? Okay, then it's,
The judgment.
okay, sorry, it's my fault. Bundle C, page 212. 4.0. Item 4. Paragraph 71. I don't know what page.
Chapo, talking alone or talking to us? Oh, okay.
Yeah, it is that one. Thank you. You are just on time, Chapo, before you before you were defamed. Okay, paragraph 71. Can you go through that, PP? Because as I say, it's probably at the heart of anybody who tries to understand this issue, this thing of remedy and how you remedy a situation, and the fact that it's depends. You can't just know what the remedy is without knowing the root cause. Yeah. Okay.
Yeah, in some, the public protector's power to take appropriate remedial action is wide, but certainly not unfettered. Moreover, the remedial action is always open to judicial scrutiny. I think that's very critical.
Yes.
It is also not inflexible in its application, but situational. What remedial action to take in a particular case will be informed by the subject matter of investigation and the type of findings made.
Yeah.
Of cardinal significance about the nature, exercise, and legal effect of the remedial power is the following. A, the primary source of the power to take appropriate remedial action is the supreme law itself, whereas the Public Protector Act is but a secondary source. B, it is exercisable only against those that she is constitutionally and statutorily empowered to investigate. So yes, it's C, which is one of my favorite subsections. Implicit in the words take action is that public protector is held self-empowered to decide on and determine the appropriate remedial measure. And action presupposes, obviously, where appropriate, concrete, or meaningful steps. Nothing in this way suggests that she necessarily has to leave the exercise of the power to take remedial action to other institutions, or that it is power that is by its nature of no consequence. So this is, if I expand, let me go to the other one. She has the power to determine the appropriate remedy and prescribe, yes, D as well, the manner of its implementation, because it also guides the said institution. And what is appropriate means nothing less than effective, suitable, proper, or fitting to redress or undo the prejudice, impropriety, unlawful enrichment, or corruption in a particular case. So only when it is appropriate and practicable to effectively remedy or undo the complaint would a legally binding remedial action be taken. So also informed by the appropriateness of the remedial measure to deal properly with the subject matter of investigation and in line with the findings made, would a non-binding recommendation be made or measure be taken. So that's where there's a non-binding remedial action. So whether a particular action taken or measure employed by the public protector in terms of a constitutionally allocated remedial power is binding or not, or what is its legal effect is, would be a matter of interpretation aided by context nature and language,
Thank you.
which is very critical.
That's
also. Yeah.
more than critical. I think when we do get to CX, we will
CX,
have almost covered half of it.
Yeah.
Because isn't that the important thing? You were insulted, vilified, and belittled for that remedial action to do with the mandate of the Reserve Bank. But according to the Chief Justice, that mandate, or rather that remedial action, must be interpreted aided by context, the nature, and the language. So let me just ask you straightforward, because that's really what the CX case is all about. When you were making that remedial action about the proposed amendment of the Constitution to benefit the poor, it's explained in your report. The interpretation that is given is that you were by then in your report amending the Constitution. Is that even, does it even make sense to you?
It doesn't make sense and impossible for me to do that, because I think where it deals with the manner of implementation and how to do it, that is the responsibility of Parliament. I think there was where in the recommendation we were saying they should consider this particular committee to look into that particular matter. And what was perpetuated out there was that I said the Constitution must be changed and or the Reserve Bank must be nationalized. But what I was showing was that with the current mandate of the Reserve Bank being in the Constitution, the drafters of the Constitution, when they put it there, it's a challenge because generations and generations and generations to come, those who are still young, who will be listening to me when 50 years, 60 years down the line, if that is still the case, we will still be where we are today. So it was trying to deal with the issue of the mandate and how the mandate can be in such a way that actually, if possible, for me, I would say remove it even from the Constitution, have the national legislation, and it will be directed to as and when the conditions of the country changes, because it was also the issue of unemployment. How can you utilize the Reserve Bank to assist in the employment creation, and how the funding of very serious state projects and everything, utilizing that institution, because I think it was purely based on that, and purely based on that because of what I've seen in the report and in the judgment of the Constitutional Court. And every time when I meet with the team and would say, but what remedial action to take here? And I would say to them, those paragraphs which we put there in each and every report, also internalize them as a senior investigator. It will guide you what remedy to put or to come up with. So it was purely based on that. And I never had any sinister motives or whoever thought I am encroaching on the mandate of the Reserve Bank. That was not my intention, but I was saying the Reserve Bank is a state organ.
Yes.
How do you use it to benefit the masses?
Yes. Now, you are the public protector of South Africa. That's a serious thing. It's a very serious and weighty office. And maybe something that we don't understand is that once you are given that office, then you have certain powers. Can anybody, apart from the court, at least, whether it's the Reserve Bank or the DA or whoever, actually second guess you if you find that that's the root cause? Let's assume it's the wrong root cause. But once you find that that's the root cause, and then you find a remedy for it, can someone say, no, you are incorrect? Not that it's reviewable, but that you are incorrect. In other words, second guess you as a public protector. Is that even allowed?
It's not allowed. I think it happened with my predecessor in the Nkandla issue, because there was a committee of parliament which came up with everything. But the issue is, if you can't implement it, and I like that paragraph which says the judicial scrutiny, and that's a self-cleansing issue, because I don't have unfettered powers. It means I can't abuse my powers. If I came to that conclusion and it's wrong, then that's why institutions have a right to take me to court, and the courts can come up to different conclusions, especially on the application or applicability of the law, that whether what we came out with, is it proper? So you cannot just say, no, you are wrong. We are not going to do that. But I must indicate, SC, that when I engage with my counterparts from Africa, because some of them would say, we would want our remedial actions to be binding. But I think we're still coming to that issue of the mandate of an ombudsman, because the ombudsman is there to assist, to hold state institutions, to show them how or where you are going wrong. Because unfortunately, this Constitutional Court judgment made our remedial actions to be regarded as if it's now a court order. And it brought us into kind of possibly competition to the courts, which it was not intended to do that. Because as South Africa, we can choose to say, here's this institution, it's helping us, it's conducting investigations. Because normally I would even say to ministers, when I engage with them, why spend money in forensic investigations when you yourself can lodge a complaint with the public protector and say, public protector, I'm picking up the following governance issues. Can you help me investigate and recommend ways for me? Because that institution should be treated like that. But unfortunately, there's that antagonistic way of being treated. And that's where I'm sitting here.
Yes. Well, exactly why you're sitting here. And I must say, I'd like you to comment on this, because even it was difficult for me to even work it out in my mind, because having been involved in the Nkandla case, I always thought that we did the right thing by pushing the envelope to the extent that the remedial action of the public protector is binding. We all thought, yay, we've just done this big monumental thing. So it was shocking to me, at least my system, when Honorable Sokoni actually said, no, that's actually the problem. Because once you have remedial action that is binding, then your public protector is going to be in this. That's why you are sitting here, she said. If it was just recommendations, nobody would have even thought of an impeachment, but it's because of the bite. And that, I must say, was something that was like a wake-up call. So do you agree with Honorable Sokoni that a better model might be, and now, as I say, you said you are speaking for the future generations, that as a country, we should debate this issue as to whether we want the remedial action that is binding or one that is a recommendation based for, among other things, to stop victimization of people like you and your predecessor, because even for her, the insults only came once after the Nkandla judgment, which declared the remedial action to be binding.
Definitely. I think the mandate of the, again, it depends on the maturity and the political will. I think it goes back to that. And also, as a country, how you'd want to change the operations of the country to suit you know, the operations or the governance of the country. Because at the end of the day, if it can be taken in that spirit,
Hmm.
that yes, is binding unless set aside by the courts, and people are not taking it as if it's a court judgment, because you'd be surprised how many times after we've issued a Section 7(9) notice,
Hmm.
then there is that issue of people thinking, no, you are going to find me guilty. We don't find people guilty, but we are saying, here you violated this law.
Hmm.
And then we are proposing that you correct it as follows. And when they respond, I mean, we're still going to deal with the Godan Section 7(9), the PLA and everything. Instead of addressing the key issues or the evidence and saying no, but yes, here we see this is how we can improve. No, they don't address those, they address the technical issues. So I would think that indeed a debate is needed as a country. Here's this Constitutional Court judgment. It's existing. If we implement it, can we change our mindset? Can we not treat the public protector as if is this we will vilify a person, an incumbent who is doing their work according to what the Constitution, the Nkandla judgment, or the courts have indicated they would do. You're still going to deal with the Pretoria High Court judgment on the state capture report. I mean, you've seen what the judgment was saying, that even the powers of the public protector, you can issue a state capture report which separates, which has 3 stages. You can only investigate, sometimes it's fine. You can only issue observations are also binding.
Yes.
You can also usurp the powers of the president. It's fine. So I think it's how we should be dealing with those and implementing those. And I think also possibly we shouldn't be looking at who is the incumbent, but check the repercussions of our judgments and decisions towards those institutions.
Yes. No, thank you. Okay. I'll take the blame for that state capture judgment as well. Again, we argued to the court that it was important that observations should be recognized.
Yes,
So I can assure you, if we had not succeeded, you would not be sitting there now. But be that as it may, I think the tight point really is, and that's the point I think Madam Sokoni was making in seriousness, is that ironically, it might well be that the public protector's office has got too much power vested in one office. And that, as I say, which we all thought was a good thing, the unintended consequence is that you then become a sitting target for all sorts of scoundrels to persecute you as soon as you point out to their corruption without adopting my words or putting words in Honorable Sokoni's mouth. I'm simply saying that, is that a debate we should have? And you won't be accused of amending the Constitution. But I'd like to get your views on that, because contrary to popular belief, this cannot be blamed on the Constitutional Court. The Constitutional Court's job is to interpret the law. If we want to change it as a country, we must just change the Constitution. The Constitutional Court is not going to change it. But at what level should that debate be pitched so that if it ends up with a constitutional amendment, so be it? And is there such a thing as being too powerful, which then puts you in the position you're sitting in today?
I think the Public Protector Office, the way it's crafted, I think you took Honorable Sokoni through the institution of ombudsman, because remember the king wanted an office of an ombudsman to deal with, or to be a check and to check their behavior. Indeed, it's one of the very high profile office, because if you have to investigate the king and inform the king, you are not correct here and here. So the way it's or where it's pitched, it's fine. But the issue is when, again, the issue of political will, the issue of people understanding that they only focus on administrative issues, and how can you use that office as a leader to be your 360 degrees check, because you will then gauge from what is happening in the country and indicate that, you know, here we need to look into this matter, here we need to change the following issues. So I would say, even if we keep it at that level, or again, I spoke about amending the Executive Members Ethics Act, because we can amend that legislation, because I think a lot of the troubles and the problems also for this public protector is the issue of operating in that political space, investigating under the Executive Members Ethics Act, being accused now, charges 11.4, 11.3 and 11.4, that you are favoring certain politicians, whereas you conduct your investigation without fear or favor. You are then threatened with personal costs. I pay personal costs. I mean, the CX matter, I should indicate that my house was broken into. I opened a malicious damage to property issue, the telephone calls one has received. So it goes to that particular level. And the mistake, again, people are doing is that some of them will say, we are waiting for the public protector report before. I mean, if a crime is committed, the Hawks should be going and do their work. Why wait for the report of the public protector, or why wait for the referral from the public protector? So I think that debate should be engaged, and there should be amendments to the various legal framework or legislations, even the very same Public Protector Act, if it means doing that, to make sure that you use the institution to the benefit of the public. You don't use the institution, or some people will then say, this institution will help us to fight our political battle as alleged.
Yeah. Well, I suppose you should blame not this committee or the chairperson, you must blame the King of Sweden in 1713, who came up with this idea. But I think on a lighter note, if a king could actually conceptualize an office that was going to scrutinize him or her, I think it was a him then, isn't that really where the catch is? That if you have a different king, then even if you suggested that they did anything wrong, they'll probably have you killed. But a particular king who might say, I need this so that I can be a better king. Isn't that also a matter of mindset? In other words, bringing it now 300 years later, that it is actually those people that Chief Justice Mkhwebane called the repositories of raw state power, how they receive your criticism, your remedial action, your findings. Because one set, if it's a Nelson Mandela, they will probably, as you said, say that we need this, we need to be scrutinized. But not everyone is a Nelson Mandela. Others will say, well, let's suspend her tomorrow. What needs to be done at that level of those people who are being investigated themselves, not seeing you as the enemy of the state?
Yeah, I think you've mentioned Nelson Mandela when he was addressing the university in Taiwan. And I think in one of my address to a TUT, where I also dealt with the issue of him subjecting himself to even going to court, remember, the Louis Late matter. And he never felt, Uguti, you know, I'm this powerful person, I can't account. Because what is currently happening, it has degenerated to such an extent, again, that Africa is looking up to us, where you find we are talking left, walking right. This institution is there in the National Development Plan of the country. The critical policy paper where you're saying you are one of the institutions which will help us to deal with governance issues. But then you go ahead, you don't fund this institution, you defund it, you cut their budget, and you treat the incumbent with or instilling fear. So who would be the public protector who will then sacrifice their children's money, who will sacrifice their safety, who will also then sacrifice their work? Because currently I'm under suspension because of what I was trying to do. I was doing my work. And hence I would say you wouldn't find a minister of police after a wrongful arrest or wrongful imprisonment where you'd find them paying personally from their pockets because of the behavior or conduct of the police officer who did that. But again, it goes back to political will. It goes back to saying you cannot also have that, because we are dealing with abuse of power as a public protector. Public servants, you are servants. You are not, I mean, from president, ministers, you are servants of the people. Members of parliament who are here are the voice of the voiceless. And the importance of this institution is that it's not a court. It's free. You have any other person who will come to us and we assist them. But unfortunately, you find then the raw state power, those who have deep pockets, then taking you to court. And unfortunately, then you find that sometimes, yes, we will deal with those court judgments and how they came to being and what papers were before them. At the end of the day, we are losing what it was intended to do. You know, when I was doing the training or the going around the provinces, always when we deal with EMEA addressing the new MEC's provinces, where I used to take through them the Executive Members Ethics Act, and you know, say to them, the test here is so minimal. It means you should be spotless, because I mean, if the Executive Members Ethics Act is just saying to you, or even directly from Section 96 of the committee of the Constitution, you should not expose yourself to a conflict. Doesn't say you must have a conflict. And it means you need to behave in that way. And when we issue the report to you, learn from that. Going forward, don't repeat the same thing yourself as that particular person. So I think there's a serious debate which needs to be had, and especially planning for the future.
Thank you very much. Well, okay, can I do this because I have a section to cover? I know that, and I communicated to the chair that for various reasons that we don't need to get into, chairperson, the witness had asked not to go beyond 5. So I'm appealing to both you and the chairperson to go slightly over, maybe by 10 minutes, so that I can just kill this one topic. Is that okay, Public Protector?
Yes.
I know it's been a long day, but can we just cover one more topic? Because otherwise, if you don't want me to start with that topic, then I'll ask to stop here. Can we?
We can proceed. Chairperson, we slept around the AMs, and yeah, I'm not feeling okay.
Yes, please tell
we'll
him.
proceed.
We did not sleep because of him, because he gave us one day to prepare. But
Yeah, you can proceed.
Thank you.
Thank you, PP.
Thank you, Chairperson. Sorry, PP. We're trying to, okay. In fact, I'll do it like this, Chair. Again, if there's no objection, I'll try and speed it up by just reading out and getting you to confirm some of the issues. All right, you've covered the prosecutor and so on. Then at 58, you say, I was later transferred to the Department of Justice head office in 1996 to work as a legal administration officer with International Relations Division. My area of responsibility was extradition law and mutual legal assistance. I was also trained in Syracuse in Italy on extradition law. Confirm that?
Yes.
And then you say you participated in various human rights law projects and was part of the team that drafted the South Africa's country report on human resources. Yes, thank you, Tsepo. And people's rights. which was deposited to the African Union when you were further a member of the coordinating committee that drafted the National Action Plan on Human Rights, which was deposited to the United Nations High Commissioner on 10th December 1998. Confirmed?
Yes.
And if you want to comment a bit about it, then we'll go, but let's try to move. I worked as a senior researcher at the South African Human Rights Commission from 1998 to 1999, where I was tasked with compiling a country report on the status of human rights in South Africa.
Yes.
Yes. Yeah, then you say your first interaction with the Public Protector of South Africa was when you joined the institution as a junior investigator in 1999. Okay, we've covered that. We can jump that one. At paragraph 62, you say your portfolio involved a strong record of 11 years in senior management within immigration services at the Department of Home Affairs. I think one of the witnesses, again, I can't remember, I think it was Mr. Lamula, yes, who had worked with you in at Home Affairs. Just briefly, what were the learnings or part of the, because it seemed to be very relevant, that stint at Home Affairs in particular, what did you bring into the Public Protector's Office from that?
And, you know, working for Home Affairs also helped me a lot in the issues of service delivery. You know, working there, I don't know then, but that's one of the very much involved, or well, the department, we used to work so hard because I mean, I think the other paragraphs where we are dealing with the establishment of those refugee reception offices, but then working with the public, and especially I know a lot of the ministers there, former Minister Mapisa Ngagula, former Minister Nkosazana Dlamini Zuma used to say, you know, Home Affairs is at the core of the country, because from birth to death, they are the ones who are busy with, or they help you. And it's at the core of what we do as the public protector, because if a person is not issued with an ID, if a person is not issued with a birth certificate, death certificate, to even bury your loved one, because it costs a lot for you to go through that particular process. So working there, and especially in immigration services, also helped me to understand the international human rights relevant prescripts, and also dealing with the issues of treating a person as a human being more than any other thing, because that's where you'd realize that people run away from their countries, being persecuted by the country, and coming to South Africa, being exposed, being vulnerable. What do we do as public servants to help people like those and not capitalize on their vulnerability? Exactly what we are doing at Home Affairs. And I think that also taught me to, you know, treat a person and not discriminate on that particular person. I remember there was a stage where at home, when I was working at Home Affairs, and even now, there are terms which you wouldn't deal with when around me, because I could understand the seriousness of how that makes a person feel. So, I mean, the situation of Zimbabwe in 2006-07 also then opened up a lot of hard work, working on time, working throughout the nights, processing asylum seekers. So also that was the experience I could benefit. And hence for me, it was not an issue for just rolling up my sleeves and working, being at the senior management level, but working and assisting the
Thank you.
the public.
Yes, and at the risk that I will be called xenophobic or Afrophobic, which I'm prepared to take, because that's what happens in this committee. If you repeat obnoxious nonsense, then it's ascribed to you. Are the terms that you're saying you became intolerant to and could not be used around you, such derogatory terms which are used like amakwere and all sorts of nonsensical terms like that? How did that educate you to be able not to treat fellow Africans like that?
That's why I'm saying, I mean, if you hear a person saying, I'm from the eastern part of DRC, I ran away, I crossed the following countries, yes, it's a challenge. There are those instances where as well, being a refugee status determination officer, the ones I was managing, and also when we conduct research and you discover how they are being treated in their own countries. Then you come into the country, which I still feel South Africa is still not protecting refugees and especially genuine ones. I don't mean economic migrants who then also some of them commit or enter the country illegally. But genuine refugees for me is how do we properly protect them, but as well for the public to know about them and how we integrate them into society. So hence I'm saying to you, for me, it was treating that person as a human, which is firstly humanity, more than anything else. Yes.
Thank you very much. All right, then you say, I provided strategic leadership on refugee services. I think that's what you've just covered now. Especially Gauteng, Western Cape, Eastern Cape, KwaZulu-Natal, and Limpopo, where refugee reception offices were located. I monitored rollout of integrated biometric system to 5 refugee reception offices and increased the staff complement from 20 to 300. Then you say, during the course of the political instability in Zimbabwe, around 2006 and 7, you provided strategic direction for processing asylum application, which spiked from 50,000 to more than 200,000. I think that's what you just described as the most hectic time. Then you say you participated in the drafting and signing of the tripartite plan of operation for the reparation of Angolan refugees between South African Department of Home Affairs, Angolan Department of Home Affairs, and the United Nations High Commissioner for Refugees. You also were appointed as a board member of the Refugee Relief Fund Board by the then Minister of Social Development. Which one was this?
Zola Square.
Dr. Square, yes. And you participated at various UNHCR EXCOM meetings in Geneva, in Switzerland. You participated at the AU meetings in Ethiopia relating to refugees. A key achievement in this regard was the adoption of the AU Convention relating to displaced persons in Africa.
Yeah.
Part
so-
of what you've just described.
Yeah, this is it was very critical because displaced persons, then they lead to issue refugees, because remember, there's a conflict in a country, then people are crossing from either Ethiopia to the neighboring countries. Then what happens is that those people then will be traveling to other countries for safety. They end up then being asylum seekers in other countries. So I think that was to say, Africa, how do you deal with the displaced persons so that you then manage to deal with your own citizens in a way, preventing the spillage of asylum seekers. So
Right.
this was a very critical achievement.
Yes.
Mm.
And then you participated, you represented South Africa at SADC Refugee Commissioners meeting, and you presented papers internationally on refugee policy in Germany and within Southern Africa. Confirmed?
Confirmed.
In 2010, you were appointed as a Councillor Immigration and Civic Services as a representative of the Department of Home Affairs at the office, which is based in the People's Republic of China. And as such, you had to relocate together with your family to live in China. You facilitated the establishment of the visa outsource offices both in Beijing and Shanghai. This included standardization of operations of the two missions, improved customer service and service delivery to deepen political and economic relations between the People's Republic of China. You were based in China for 4 years and 6 months, and then you negotiated more such visa facilities since the government had to approve such if centers needed to be opened in areas there. So that was your stint in China.
Yeah, and just to add, because that's where the DA was accusing me to be a spy, and I was based in China. And I remember one of the journalists, I forgot his name, his surname. He even went to China to just interview Chinese about my being there. But then at first I was supposed to be deployed to Geneva, Switzerland. And I think when Mapisa Ngakula changed or moved to another department, when Dr. Nkosazana Dlamini Zuma was the Minister of Home Affairs, then she said, no, strategically, we receive a lot of economic or tourists from China, and we need to make sure that we build and develop the relations and capitalize on that. So then she said, no, in Geneva, it's like a cream mission. You'll just sit there, just attend EXCO meeting. But we need people who will make sure that there's a processing of visas, but again, at the senior management level, because to check the issues of fraudulent issuance of visas, those who will be traveling without proper documentation, and to prevent issues of illegal migration. So hence, I didn't go to Switzerland, Geneva. Maybe if I went to Switzerland, Geneva, I wouldn't
be a
labeled
spy.
I think so. Yeah.
Yes, no, that's fine. I think let's deal rather with serious things. Okay, so and then this CV, I must say, is I'm not sure is this for one single person, but but let's go through it. So due to the excellent service delivery and the impact it made on relations between SA and China, an article was published in the local China daily newspaper, which we've been looking for, regarding your achievements. But you drafted the chapter on immigration, the green paper. We will upload it, Chair, when we find it. Relating to management of the asylum seekers and refugees. In 2014, you returned back to South Africa. You worked at the Department of Home Affairs as Director, Country of Origin Research within the Chief Directorate, Asylum Seeker Management.
This paper, Chairperson, paragraph 68, I don't know how far the process is, but it was also going to help the country in developing this paper and dealing with SADC neighboring countries and the issue of movement between the SADC region as a build up to the African integration, because that's how your Schengen countries or the Schengen visa was developed. So I don't know how far is this process, because that was going to also help in the integration of SADC And the issue of moving away from, this issue of segregation or perpetuating the Berlin destabilization of Africa. So I think it's going to help if in future they can just focus on that, because you can't eat an elephant, but you bit by bit, if you start with SADC, then you integrate with ECOWAS and other countries, then Africa will be one. Yeah.
And then, you just joked about the serious matter of being called a spy, but the part of what and you that 007 thing was a mere 3 months.
Only 3 months, yes.
Only working 3 months in a place after all this beautiful CV. Anyway, you say you started working for the State Security Agency as senior analyst in July 2016, and that would then mean it was the 3 months before you were appointed as public protector. Yeah. Okay. And you say my responsibilities included advising Director Domestic Branch on compliance to constitutional provisions while protecting the state actors, which are people, government, values, territory, legislation, and stakeholder relations. I held this post for a period of only 3 months before my appointment to occupying the position of public protector. This short stint could not by any means qualify me for the slur by the DA of being called a spy. And then you've already commented on that.
Yeah, I think I commented on that, and how critical it is to have State Security Agency, which is a constitutional institution, which I've been saying it's treated as if it's an outcast.
Yeah.
And they never as well, their communications or marketing to just educate South Africans. People who are working at State Security Agency are public servants, they are civil servants themselves. And then you would have those who are working undercover. And those ones, you wouldn't even know about them.
Yeah.
You wouldn't even go to countries like China and be regarded as a consular immigration. And I said that in the past, that now it's like you want to cause civil war, between countries because of your own selfish agendas. Just accusing a person that they are a spy. But what I would say is that that is a constitutional institution. That's why you have those legislation, you have MIS and everything, which to this day I was shocked to hear that people have an opportunity. I mean, as far as I'm concerned, everyone from the president to the ministers to the members of parliament should be security vetted, because that's where, as a country, you know who you are dealing with. So yeah. Right.
And so I see. So you're saying maybe the war that we see out there could be nothing if China had such infantile logic to think that South Africa sent a spy there, then they could come and kill us all here. So fortunately, they don't belong to that crowd. Okay. Now at paragraph 71, I was appointed South Africa's 4th public protector for a non-renewable 7-year term by President Jacob Zuma, effective on 15 October 2016. That part we know. And you've said about what happened around your interviews and who supported you. Oh, by the way, sorry, another typo that we will deal with, correction, there's something about 12 political parties, and you pointed out to me that it's 14 political parties. But we'll deal with it with the evidence leaders here. All right. This followed a thorough and transparent selection process carried out by Parliament. All but one political party, the Democratic Alliance, and COPE abstention in the committee endorsed my candidacy. And then you say in July 2018, I was appointed the first vice president of AOMA. We've heard about that from Honorable Sokoni. Also a board chairperson of the Durban-based AORC, which assists IOMA with research, information capacity building, and advocacy. Confirmed.
Confirmed.
And in December 2018 to date, you were elected as the president of IOMA during the association's 6th General Assembly in Kigali, Rwanda, correct?
That's correct. And they should be having elections soon. Yeah.
Yeah.
To
Okay, so
appoint the next, yeah.
okay, so are you campaigning to want some? You want
My
some,
term is ending in October. Yeah,
October,
we must get young and yeah.
Okay, now I was going to organize some CR17 money.
To campaign.
Okay. No, now at paragraph 75, you say you served on the board of the International Ombudsman Institute, a global body of public protector type institution, which is headquartered in Vienna, Austria. Now, this part, I need you to deal with it yourself because for me, I think it crowns, I think, what is this beautiful curriculum vitae. I cannot believe that anybody can achieve this in a short space of time and still endure this kind of ridiculousness. But if you can just read and take us through paragraph 76.
Okay, in dealing with my experience, I wish to isolate 5 important aspects which have, in my humble opinion, set me apart from all my predecessors, which may be answerable for my far better achievements in the fulfillment of the mandate of the public protector. And these are the first one, my humility based on my humble beginnings and the early installation upon me of the value and rewards of hard work, as I've indicated above, that I think working at Home Affairs is one of the best experience ever, or anyone who worked at Home Affairs. To me, that's one department which will build you and will, show you how to be hardworking. Though, yes, there are a lot of challenges there, but I think that's what shaped me.
Yes. Okay. 76.2.
My faith and belief in God and my outlook and quest as a devout Christian to do unto others as I would want them to do unto me. I think this one was also mentioned by Mkhwebane. But I think that's what also keeps me standing, praying a lot, and all those who are praying for me. And though sometimes I was shocked with some of the members who are said to be Christians, the way they are treating me. But I think, I give that all to God. Yeah.
Don't worry. I think that myself, in my world, it says what goes around comes around, what comes around goes around, what goes around comes around. But in yours, I think it says turn the other cheek. Well, not me. All right.
My work experience, in such pressured environments, such as the Department of Home Affairs, also helped me a lot.
Yes.
Besides Home Affairs, as a public prosecutor, working at the Human Rights Commission, though Human Rights Commission was more based on research, but also then trying to understand what is expected from this constitutional democracy.
Okay, thank you. I wanted to say that I've shared that joke with you, that in your world, your motto is turn the other cheek. In mine, if you hit my cheek, I hit yours. So that when I turn the other one, you won't hit it again. But there you are. All right, 76.3, you've covered. 76.4, you what is your fourth achievement, well, not achievement, motto or motivator?
Yes. This is an incomparable and invaluable insights and hands-on experience I gained from previously working at the Public Protector Office. Actually, as a senior investigator, I think we need to correct that. As the senior investigator, and I also worked as the provincial public protector, because I normally call them provincial public protectors, the acting one in Gauteng, and that opportunity was given by the former public protector, Advocate Mkhwebane. So also then showed me the different perspective of how the provincial office of the public protector operates. And
Okay, then can we go to the last one, 76.5? If you can go through that one.
so above all, I believe that I cannot betray my beliefs and my people because of the evil deeds and intentions of
Sorry,
my
I
distractors.
can't hear you. Chabi. Yeah. Thank you.
This place is so uncomfortable, Chairperson. Yeah. Above all, my belief that I cannot betray my beliefs and my people because of the evil deeds and intentions of my detractors, which requires me to stand firm in the face of adversity, guided by the spirit and ethos of other prosecuted women who came before me, including Winnie Madikizela Mandela, Rosa Parks, and Esther of biblical times, who famously stated that she would not look back on her mission to face the all-earthly ruler and powerful king. She stated defiantly to her people, as reflected in the book of Esther 4 verse 16, where she said, go gather all the Jews in Susa and hold a fast on my behalf, and do not eat or drink for 3 days, night or day. I and my young women will also fast as you do. Then I will go to the king, though it is against the law, and if I perish, I perish. I think this verse I mentioned when I was about to issue the rogue unit or the so-called rogue unit report, and unfortunately also that's what happened, because it was like when I was trying to guide and show what needs to be done, what were the root causes of the problems going forward, how to change that, then it was unfortunately interpreted to be something else. So this also is one of the verses which gives me strength.
Thank you.
Yeah.
And then you go to paragraph 77.
I too will face the powerful face to face only because the new land compels me to do so. And if I perish, I perish. It is an essential requirement of my current office to conduct myself or the investigations without fear, favor, or prejudice. Therefore, I am not scared of anything or anybody. I think that's what transpired. Unfortunately, sometimes it's too much for my family, my children, but I think it's for the better good of the generations to come, because I think all of us should be selfless. And unfortunately, I'm not gaining anything for doing this work. But what I would want to do is to make sure that South Africans, all color, creed, status, they benefit from this institution.
Yes, thank you very much. And the last, please, if you can go to paragraph 78, just so that we round off that section.
During my testimony, I will constantly touch on the above mentioned 5 aspects of who I am and who I always will be, no matter what. I received the persecution meted out by my enemies as a gift, which can only make me stronger and hopefully inspire future generations of women patriots when required to walk a path similar to or even worse than mine. In a further appropriate biblical metaphor, Chief Justice Mkhwebane famously described the public protector as the embodiment of a biblical David that the public is, who fights the most powerful and very well-resourced Goliath that impropriety and corruption by government officials are. The public protector is one of the true crusaders and champions of anti-corruption. Hers are indeed very wide powers that leave no level of government powers above scrutiny. Coincidental, embarrassment, and censure. Yabona ke esifundisa isilungu esikhulu. In the execution of the investigative, reporting, and remedial powers, she is not to be inhibited, undermined, or sabotaged. So this it deals with the section 181.3, which we've mentioned up there. And I think this biblical David, especially the public, again, I'm still going back to say Abo Mkhwebane, Mr. Nyatela, and what we are doing or what we did with the team to deal with the communities, Sabo Maspumelele and all those, was to exactly show to the state that we can be standing in the gap for those who cannot stand for themselves. But I think we will deal with Vision 2023, and that's where I will take you through what the intention was about this biblical David.
Yes, and for that, those big words, you must blame the erudite Chief Justice Mkhwebane. Yes, no, he's one of the most prolific legal minds that we've ever produced. But in terms of, yes, the biblical David metaphor, I think is one that is fitting. But I'd like you to maybe close by explaining why you chose, of all the verses, a verse that really is probably fitting to where you are sitting today, and why it is that your determination takes you to a place where your refrain is, if I perish, I perish.
I mean, if you represent or you are dealing with the poor, the marginalized, people who don't have the means or the resources to fight for themselves, and if I am honestly, or we are working with what is before us, because when I say, if I perish, I perish, I mean, if investigating the most powerful, I mean, if we were investigating the Busasa matter, the kind of evidence we considered, and then you need to make sure that you are honestly, independently, without fear, without favor, compile reports, especially the investigators. I think there's one at one stage when you were asking either Rodney or Bianca to say, if when investigating those matters, does the public protector say to you, now we are going to target this particular person, or now so this means all the vilification which I've been facing, and I indicated earlier that the financial mails report, I mean, it was even worse because I think even other institutions had to intervene about SAC, South African Council of Churches, when they even went to take pictures of my late mother at that age, because of people trying to show you that we can deal with you whilst I'm doing my work. I mean, the issue of paying personal costs to this day. I mean, if you are a public servant and you ask yourself, was it justifiable for me to do that? So all those threats, I mean, the kind of comments and the kind of embarrassing words and statements which have been said about me. And I think through it all, I'm just doing my work. I have nothing to gain from whatever I'm doing. You know, if they are saying for every insult I get, for every ill treatment I get, I am paid, I would say possibly, yes, I deserve it. But the question is, through it all, I'm just trying to liberate those who are not having any means of liberating themselves, because it's still a long way to go. And if we can check how people are living when you go to the rural areas, when I do the road shows, the hospitals, the education system, access to water, which are basic things. And that's all what one is doing, instead of then being selfishly leaving people who are just plundering the resources of the state just to benefit themselves. So I think people don't want to lose face. In Chinese, they are saying that when you tell a person the truth, they lose face, and they will be they'll be very, very, very lethal when they deal with you. Yeah.
Thank you. All right. Thank you, Chairperson. That covers the landscaping issues. And thank you, both Chairperson and Public Protector, for giving us those extra minutes. I just didn't want to leave some of those issues hanging. We will now and again touch back on some of the issues of landscaping that we have not covered, Public Protector. But I think that gives us the context. So tomorrow we will then, as you say in your statement, start with the real reason that you are here. And therefore we will be dealing with the CR17 Busasa matter. And we will go through the report and the judgments, and then you will give the analysis of why that report is part of what you say has landed you in that seat. Thank you very much, Chairperson.
Thank you, Advocate Mpofu. Thank you, PP, for the day. The time now is 21 minutes past 5. We're going to pause here and adjourn the meeting for today. We'll resume tomorrow at 9 and not 10 in terms of the program, to give an extra hour. So thank you, colleagues. Do you have a difficulty with 9?
I do, Chairperson.
You don't want to wake up?
No, Chairperson. Well, waking up is not the problem. The problem is that we did not sleep at all. Chair, is it possible? Okay, let me just consult 1 second. Chairperson, my team is asking for 10, and I really would like to represent them. Literally, some of them did not sleep at all. I slept for a couple of hours.
Fine. Honorable members, 9:30 or 10? 10. Okay. You have support from the members.
Thank you very much. Let's leave it before it's spoiled. Thank you very much.
Thank you. We'll resume tomorrow.
Appreciate it.
Thank you.